Good afternoon. I know this is a very unexpected life, but I didn't know we were going to have court today. Oh my gosh, we've got court. Go figure. The twisted torture murder trial with Sean Finnegan is live today. I was like, what? It's live today. I thought I lit this. Um, and it's in a verdict watch. The judge has been handing down the instructions to the jury, and my hearing aid. Oh, there it goes. So we're in verdict watch. Go figure. So I'm going to hop it up, and y'all can see it too. We can listen to the last bit, I guess, or we can start from the beginning. Let's see how long this is. We're going to start from the beginning. They did take a lunch break, but we'll skip through that. So let me get everything lined up and get everybody up and going. I was shocked. I didn't realize we were going to have this. So here we go while the judge is coughing.
But if you need to take a break, as we're going through this, a bathroom break, just raise your hand and I'll stop it off with. Deal? Okay. All right. Let's get started on this.
This is live today.
Shannon Finnegan is charged in indictment C1C0051A with the crimes of first degree premeditated murder, first degree felony murder.
I don't know what all the noise is in the background. So calm down.
Especially aggravated kidnapping, abuse of the corpse, and tampering with evidence. Count one charges the defendant with the offense of first degree premeditated murder of Jennifer Paxton. The offense necessarily includes the lesser offenses of facilitation of first degree premeditated murder, second degree murder, facilitation of second degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 2 and 3 charge the defendant with the offense of first degree felony murder of Jennifer Paxton by alternative means. Count 2 charges felony murder during the perpetration of or attempt to perpetrate aggravated kidnapping. And count 3 charges felony murder during the perpetration of or attempt to perpetrate aggravated rape. Each of these offenses necessarily includes the lesser offenses of facilitation of first degree felony murder, second degree murder, facilitation of second degree murder, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 4, 5, and 6 charge the defendant with the offense of aggravated rape. Each of these offenses necessarily include the lesser offenses of attempted aggravated rape, facilitation of aggravated rape, aggravated sexual battery, attempted rape, facilitation of rape, attempted aggravated sexual battery, facilitation of aggravated sexual battery, facilitation of attempted aggravated rape, facilitation of attempted rape, facilitation of attempted aggravated sexual battery, attempted sexual battery, and facilitation of sexual battery. Count 7 charges the defendant with the offense of aggravated kidnapping. This offense necessarily includes the lesser offenses of attempted aggravated kidnapping, facilitation of aggravated kidnapping, attempted kidnapping, facilitation of kidnapping, facilitation of attempted aggravated kidnapping, facilitation of attempted kidnapping, false imprisonment, and attempted false imprisonment.
Hello, Deborah. Good
Count 8
afternoon.
charges the
Welcome.
defendant with the offense of especially
I'm
aggravated
finishing my breakfast.
kidnapping. This offense necessarily includes the lesser offenses of
The
attempted
best
especially aggravated
kolache.
kidnapping,
Check.
facilitation of especially aggravated kidnapping, attempted aggravated kidnapping, facilitation of aggravated kidnapping, facilitation
I know.
of attempted especially
I'm just going to try and get covered.
kidnapping, attempted
Try and get caught up.
facilitation of
Do we need to hear all this?
facilitation of attempted aggravated kidnapping, facilitation of attempted
See
kidnapping,
how it sounds a little
false
faster.
imprisonment, and attempted false imprisonment. Count 9 charges the defendant with offensive conspiracy to commit first degree premeditated murder.
Here we go.
This
We got
offense
captioning.
includes the lesser offenses of conspiracy to commit second degree murder and conspiracy to commit voluntary manslaughter.
I don't know
Count
much
10
about
charges
this
the defendant
case.
with offensive conspiracy to commit aggravated rape. The
I
offense
was going to
necessarily
binge
includes
watch
lesser
it this
offenses of
weekend.
conspiracy to commit rape, conspiracy to commit aggravated sexual battery, and conspiracy to commit sexual battery. Count 11 charges the defendant with the offense of conspiracy to commit aggravated kidnapping,
This is
The offense
horrible,
necessarily
Deborah.
includes the lesser offenses of conspiracy to
Horrible.
kidnapping and conspiracy to commit false imprisonment. Count 12.
Welcome to the channel. How did you find me, my love?
This necessarily includes the lesser offense of attempted abuse of the corpse and facilitation of the abuse of the corpse.
It sounds like it. There'll be something I'll watch in private.
The offense necessarily includes the lesser offense.
I think I picked the wrong trial to watch. Maybe not.
Evidence, facilitation of tampered with evidence, and facilitation of attempted.
So how did you find us,
The defendant
love?
pleads not guilty to each and every offense.
And where are you from? Oh, you got one.
The evidence in this case has been completed, and it's my duty to now instruct you as to the law. The law applicable to this case is stated in instructions, as your duty to carefully consider all of them. Whatever instructions are given is no
Love
indication
Maryland.
of relative importance. You should not single out any one.
It's been a long time since I've been there, but I love it.
Or
I'll
others.
ask one.
You should consider each one in light of and in harmony with others. Whenever a singular of a word is used in these instructions, it may be taken equally to mean plural. Wherever
Welcome,
the word he is
speaker.
used in these instructions, you may consider it as applying equally to a woman or an entity such as a corporation. The indictment in this case is the formal written accusation charging the defendant with these crimes.
Oh, thank you, love.
It's against the defendant and does not create any inference of guilt. At times during the trial, I ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, or any remarks which I made, do I mean to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, or remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case, and also you're the exclusive judge of the law in the direction of the court. You should apply the law of the facts and assign the case. You consider all the evidence in light of your own observations and experience in life. You as jurors must decide the case based solely on the evidence presented to you within the four walls of this courtroom. This means,
Hey, Pop Sugar.
Trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved.
I'm sorry, I didn't
In
see
other words,
you,
should not
love.
consult dictionaries or reference materials, search the internet, websites,
What were you
blogs,
doing?
or any other electronic tools to obtain information about the case or to help you decide the case. Please do not try to find out any information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not
I
discuss the case with
apologize.
anyone.
I try to say hi to everybody.
After you retire to deliberate, you may
Sometimes the chats move and I don't see you.
But you cannot discuss the
Please
case with anyone
always
else
say, hey,
until
hi,
you return
hi,
to
I'm here.
the case is at an
We're
end.
so blessed to have you today,
For all
love.
of you, this case is interesting and noteworthy. I know that many of you have
I know
yourself
how that
in the past
feels,
blackberries,
and I would
internet, other
never
tools of
intentionally
technology.
do that.
You also must not talk to anyone else about the case or use these tools to communicate electronically with anyone in the case.
Now,
This includes both
if
the
I'm
case and
interpreting,
friends. You may not
I
communicate
can't.
with anyone about the case on your cell phone, through email, BlackBerry,
because
iPhone,
sometimes I
text
interpret
message,
for
or
the deaf.
Twitter, or
I know a deaf
any
person
blog or
is here
website, or any
watching.
internet chat room,
And if
or
I'm
by
doing
any other
this,
social networking
I
website.
apologize up
Please do
front.
not
I
limit your
can't.
Facebook, MySpace,
Can't do
LinkedIn,
both.
YouTube.
It's
The law
impossible.
presumes the defendant is guilty of the charges against him.
This is so
The law presumes that
comfy.
the defendant is innocent
I've worn
of
this
the
thing
charges
out.
against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you're convinced beyond reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt.
Once he stops talking, we've got Sarah Boone News
Or remains on the state throughout the trial of the case.
or
The defendant
Boom
is
Bag.
not required to prove
We
his
call her the
innocence.
Boone Bag.
Reasonable doubt is that doubt engendered created by an investigation of all the proof in the case and inability after such investigation.
Thank you for the second chance, my love.
As easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required.
Pick on
This
it.
certainty is required as to every element of the proof.
I voiced the text while I signed.
During the trial, many of you have taken notes concerning the evidence presented in court. These notes are simply to assist you in remembering what transpired in court. Your notes are not evidence or a transcript of the testimony. They're not a substitute for your recollection of your evidence that you saw or you heard in court. You may use your particular notes during deliberations to the extent you think they are helpful, but the fact that a particular juror has taken notes does not mean that juror's views should be given any greater weight than those of any other juror. The state must have proven beyond a reasonable doubt all the elements of the crime charged, and that was committed before the finding and returning of the indictment in this case. The burden is upon the state to prove by preponderance of evidence that this offense was committed in Anderson County, Tennessee. Proof by preponderance of evidence means that the greater weight of evidence must be in support of the state's contention. Venue of the offense lies where the offense was commenced or consummated.
I was just
If you
practicing.
find
I
the
had
state
him
has failed
set
to
up.
prove by preponderance of evidence that this offense was commenced or consummated in Anderson County, Tennessee, then he must return a verdict of not guilty. The defendant is criminally responsible as a party to the offenses of first-degree premeditated murder, first-degree felony murder, aggravated rape, aggravated kidnapping, especially aggravated kidnapping, abuse of corpse, and/or tampering with evidence. If the offenses were committed by the defendant's own conduct,
You're right,
by
babe.
the conduct of another for which the defendant is criminally responsible, or by both, each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to the benefit of the proceeds or results of the offense, the defendant direct, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another, if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. With regards to count 2 and 3, charging the defendant with murder and perpetration of aggravated rape and aggravated kidnapping, respectively, this natural and probable consequences rule does not apply. There is no requirement that the killing be foreseeable in order to hold the defendant criminally responsible, only that the defendant intended to commit the alleged aggravated rape and aggravated kidnapping, respectively. To find a defendant criminally responsible for the acts of another, it is not necessary that you find that the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find all the essential elements of said offense have been proven by the state beyond a reasonable doubt.
Yeah, get your sip, Judge. That's a lot of reading.
Facilitation of felony. Any person who commits the offense of facilitation of felony is guilty of the crime. Where you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the felony. And 3, that the defendant furnished such assistance knowingly. Here, knowingly means that a person acts knowingly with respect to the conduct of the circumstances surrounding the conduct, and the person is aware of the nature of the conduct or the circumstance exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it's a person's conscious objective or desire to engage in the conduct or cause the result.
Yeah, understand, Pop Sugar.
Criminal attempt. Any person who attempts to commit a criminal offense is guilty of a crime. Where you find a person guilty of criminal attempt, the state must be proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the offense under the circumstances, as the defendant believed them to be at the time, and his actions constitute a substantial step towards the commission of the offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute an offense, which intent is a lesser included offense, are set out within these instructions on that offense. Count 1, first degree premeditated murder. Any person who commits the offense of first degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim. And 2, the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement or passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt the defendant is guilty of premeditating the first-degree murder, then it's your duty, after a separate sentencing hearing, to determine whether the defendant will be sentenced to death, life imprisonment without possibility of parole, or life in prison. But you will not consider punishment for this offense at this time.
He's guilty as hell.
Beyond a reasonable doubt, the defendant is guilty of first-degree
I hope that he
first-degree
gets the
premeditated
death
murder.
penalty.
You will so report
And I
your
normally
verdict on the
don't
verdict
share
form.
that
If
opinion,
you have a
but
reasonable doubt as to the defendant's guilt,
sure in the
first-degree
heck do with
premeditated
this
murder
one.
as charged during the indictment,
Someone
your
who's
verdict must be
been a
not guilty as
survivor.
this offense, and then you will proceed to determine his or her guilt or his guilt or innocence of
Take
facilitation
it, my mic.
of first-degree
My mic
premeditated
louder
murder,
than everything
unless
else. Is that
included
better?
offense. And this too will be listed on the.
I'm sorry if I'm too much louder. I can't hear
The
myself.
essential
out
elements
here.
necessary to constitute facilitation of felony and premeditated first-degree murder have previously been set out in these instructions.
Sure.
If you
When this
find
is
from
done,
the proof beyond a
you
reasonable
know,
doubt the
the-
defendant guilty of
what
facilitation
little I know.
of first-degree premeditated
We
murder,
might even
you will
watch
so report
watching
on your
over
verdict
you.
form. If you have a reasonable doubt as to the
TV.
defendant's
How
guilt
about
of
that?
facilitation of first-degree premeditated murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The lesser included offense of
I
second
hear that up.
a person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, the defendant unlawfully killed the alleged victim. And two, the defendant acted knowingly. Knowingly means a person acts with awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means a person acts intentionally when it's the person's unconscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second degree is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of second-degree murder, a lesser included offense. The essential elements necessary to constitute facilitation of felony or second-degree murder have previously been set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of second-degree murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the indictment, the verdict must not only be as to the offense, then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser included offense. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, the defendant unlawfully killed the alleged victim. And two, the defendant acted intentionally or knowingly. And three, the killing resulted from a state of passion produced by an adequate provocation sufficient to lead to a reasonable person to act in an irrational manner. Again, the distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate
Hi, Melanie Lewis. How are
sufficient to lead a reasonable
you?
person to act in an irrational manner.
Thank you for hopping in, Melody. I really appreciate it.
On second-degree murder, please refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of voluntary manslaughter as a lesser included offense. Facilitation of voluntary manslaughter. The essential elements necessary to constitute facilitation of a felony and voluntary manslaughter previously been set out in these instructions. Refer to these instructions here. If you find from the proof that beyond a reasonable doubt that the defendant is guilty of facilitation of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of voluntary manslaughter as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall not proceed to determine his guilt or innocence of. Then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. Free to find the defendant guilty of this offense, the statements are proven beyond a reasonable doubt the existence of the following essential elements. One, the defendant killed the alleged victim, and two, the defendant acted recklessly. Recklessly means that a person acts recklessly, but a person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally or knowingly have previously been defined for you in instruction on second murder. Please refer to those definitions here. If you find beyond a reasonable doubt the defendant guilty of reckless homicide, you will so report on your verdict form. If you have found a reasonable doubt as guilty of reckless homicide as charged in the indictment, then your verdict must be not guilty as to those offenses, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. Facilitation of reckless homicide. The essential evidence necessary to constitute facilitation of a felony and reckless homicide proofs have been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. Free to find the defendant guilty of this offense.
By the way, I have the opening statement in here,
One,
and then also the little documentary.
Victim, and two, the defendant acted with criminal
So
negligence.
we'll watch those
Criminal
in a
negligence
minute.
means that a person acts in criminal negligence when the person ought to be aware.
This judge has got a pink coat
substantial risk,
underneath his
unjustifiable
jacket.
risk, substantial and unjustifiable risk that the alleged victim will be killed. The risk may be of such a
Okay.
degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person will exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally and knowingly are defined these instructions on the second degree murder. Recklessly is defined these instructions on reckless homicide. Refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminal negligent homicide, you will so report that your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminal negligent homicide as charged in this indictment, then your verdict must be guilty as to this offense. And then you shall proceed to determine if it's guilt or innocence of facilitation.
Oh, we're good, Pickle Knit. I appreciate y'all being here. And if y'all haven't subscribed, please do.
The essential elements of
We're
necessary
small,
constitute
but we're
facilitation of
growing.
felony and criminal negligent homicide have previously been set out in these instructions. Refer to those instructions here. If from your proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminal negligent homicide, you will so report your verdict on the verdict form. If you have found a reasonable doubt as to the defendant's guilt on the facilitation of criminal negligent homicide as charged, then your verdict must be not guilty as to this offense.
Jeez. How much more? Do we want to listen to all of this, guys?
Parts 2 and 3.
Got another.
First degree felony murder. Any person who commits first degree felony murder is guilty of the crime. Free to find the defendant guilty of this offense, the statement
40 minutes of this, and then we have a break,
one,
and then we've got another
or one for whom the defendant is
30 minutes. Got another hour and a half of this.
And two, the killing was committed in the perpetration of the attempt to perpetrate the alleged aggravated kidnapping, count 2, or the alleged aggravated rape,
Wow.
and the killing was closely connected to the alleged aggravated kidnapping, count 2, or aggravated rape, count 3, and was not a separate, distinct, independent
Bliss.
event.
Or
And 3, the defendant intended to commit the alleged aggravated kidnapping on count 2 or the aggravated rape on count 3. Aggravated kidnapping and aggravated rape are defined for you within these instructions. Refer to these instructions and definitions herein. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Considerations of such facts are as time, place, causation is helpful in determining whether the killing was committed in the perpetration of the alleged aggravated kidnapping, count 2, or aggravated rape, count 3. The killing may proceed, conceive with, or follow the aggravated kidnapping, count 2, or aggravated rape, count 3, and still be considered as occurring in the perpetration of the aggravated kidnapping count 2 or aggravated rape count 3, so long as there is connection in time, place, and continuity of action. When one enters into a scheme with another to commit aggravated kidnapping count 2 or aggravated rape count 3, and death ensues, both defendants are responsible for the death regardless of who actually committed the killing and whether the killing was specifically contemplated by the other. Here, intentionally means that the person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond reasonable doubt that the defendant is guilty of first-degree felony murder, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to death, life imprisonment without the possibility of parole, or life in prison, but you will not consider the punishment for this offense at this time. If you find from the proof beyond a reasonable doubt the defendant is guilty of first-degree felony murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree felony murder as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of facilitation of first-degree felony murder as a lesser included offense. The essential elements necessary to constitute facilitation of felony first-degree murder previously been set out of these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of first-degree felony murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree felony murder as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The essential elements necessary to constitute secondary murder have previously been set out in these instructions, and lesser offenses of count 1. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of secondary murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of secondary murder as charged in the indictment, then your verdict must be not guilty as this offense, and then you shall proceed to determine his guilt or innocence.
Wow, that's not good, Deborah. Oh, when they doing that, you know it ain't good.
Refer to those instructions here.
Hi, Paula's mom.
The defendant is guilty of facilitation of secondary murder.
That sounds like a plan. Thanks for listening.
If you have a reasonable doubt as to the defendant's guilt of facilitation of secondary murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed.
There are 16, I believe, indictments on this dude.
A lesser included offense.
Good to see you, babe.
The elements necessary to constitute reckless homicide previously been set out in these instructions. In the lesser offenses of count 1, refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide,
yeah. I actually demonetized myself, so I didn't have to worry about what you're getting ready to hear.
The essential elements necessary to constitute facilitation of felony and
Hey, Toxic Orchid.
Set out in these instructions. Refer to those instructions.
Oh, he's not here, but I will tell him.
Reasonable doubt that the defendant is guilty of facilitation of reckless homicide. You shall so report your verdict on your verdict form. If you have a reasonable
Toxic, we really appreciate you. You're amazing.
As charged in the indictment, then your verdict must be
welcome
as this offense
to the club. Hopefully you can join us tonight for the membership live. No, that's the first Saturday of the month. Sorry. But tonight, for everybody who's watching. So I'm not talking over it. For everybody who's watching, tonight, 7 Central, we have our Spilling the Tea. I've invited a guest. I don't know if they're going to come. And we're going to really jump into Sarah Boone. I got some tea on Sarah Boone.
This is count 1. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that
you want my mic down a little more? Is that better?
You will so report your verdict on your verdict form. If you have a reasonable doubt as to the defense guilt of criminally negligent homicide as charged in indictment, then your verdict must be guilty as to this offense, and then you shall proceed. I'm sorry. Let me read that again. If you have a reasonable doubt as to the defense guilt of criminally negligent homicide as charged in indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his facilitation of criminally negligent homicide, a lesser included offense.
Yeah, Braxton's a good guy. I think he's sleeping. He pulled an all-night.
Elements necessary to constitute facilitation of felony and criminally negligent homicide have previously been set out in these instructions. refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense.
That judge looked at the jury like, oh God, there's Mo. Get another sip, Your Honor. You earned it.
Counts 4, 5, and 6, aggravated rape. Any person who commits the offense of aggravated rape is guilty of a crime. For you to find the defendant guilty of this
If
offense,
the verdict is up to the judge, this guy is going to cry in
the
the
defendant had
field.
unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And
Thank
2,
you.
as to count 4, force was used to accomplish the act as the defendant was armed with a weapon.
Thanks,
or
love.
any
Thanks
arm
for the
used in a rational
monitoring.
manner to lead the victim reasonably believed to be a weapon to wit.
Okay, guys, I got to stop and explain something. We have a lot of new people on here. For those of you who don't know, I am deaf as a board without my hearing aids. I cannot hear my own volume. It does not offend me for you to say volume check because every trial, the volumes are different. There's nothing standard. So we're constantly adjusting everything, constantly adjusting. So we're going to play some more, and I'll be right back. Thanks.
B, as to count 5,
Fine, he got it.
defendant caused
Someone came to the door. But please understand that I try to set it at a certain percentage based on what the audio for the trial is. So if those of you who are wondering why Sneaky Side is telling me that, it's because I'm talking to you, but I can't hear myself. And I'm reading everything that I see here. So we're good. Let's go.
Injury to the alleged victim, or as to count
Right
6,
back, ladies.
the defendant was aided or abetted by one or more persons, and that force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. An aider or abettor is one who advises, counsels, or procures, or encourages another to commit a crime. Bodily injury includes a cut, abrasion, bruise, burn, or figment, or physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Force means the compulsion by the use of any physical power or violence. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any other person, part of any person's body, or any object into the genitalia or anal opening of the alleged victim, the defendant's, or any other person's body, but the emission of semen is not required. Cunnilingus means a sex act accomplished by placing the mouth or tongue on or in the vagina of another. Fellatio means a sex act accomplished with the male sex organ and the mouth or lips of another. The intrusion of the alleged victim's mouth is not required. Victim means the person alleged to have been subjected to the criminal sexual conduct. Here, intentionally means a person to act intentionally with respect to the nature of the conduct or as the result of the conduct, when it's the person's conscious objective or desire to engage in the conduct or cause a result. Here, knowingly means the person acts knowingly with respect to the conduct or the circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to be the result. Here, recklessly means a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstance exists or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances is viewed from the accused person's standpoint. Election of officers. The state offered proof in this case that you more than one alleged committed
I don't know.
offense alleged committed by
You may not be able to.
or by one. Let's start that over. The state has offered proof in its case in chief.
Anybody else know how to answer that Sneaky Side?
By one for whom the state alleges the defendant is criminally responsible, which the state alleges constitute an element of the offense of aggravated rape.
Are you going through the YouTube app or are you going through
To
the...
ensure a unanimous verdict, the law requires the state to elect which alleged act testified to the state that the state is relying upon for your consideration in deciding whether or not the defendant is guilty of the offense or any lesser included offense. The fact that the court has required the state to elect does not mean the court has found that the state has carried its burden of proving those allegations beyond reasonable doubt. That is for your determination. In this case, the state has elected to submit for your consideration as to count 4, the alleged act where Jennifer Paxton was hit with a baseball bat and forced to perform fellatio on Sean Finnegan. Members of the jury will consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses in and charged in count 4. In this case, the state is elected to submit for your consideration as follows in count 5. The alleged act where Sean Finnegan sexually penetrated Jennifer Paxton with sex toys in the vagina of Jennifer Paxton, and Jennifer Paxton suffered bodily injury with bruising about her head, chin, arms, hips, and legs. Members of the jury will consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses
I am so
charged.
sorry, guys.
Count
I
5.
can't figure it
In
out.
this case,
That is
the state is elected to
I
submit
am-
for your consideration as follows in count 6. The alleged act where Sean Finnegan is present when Rebecca Dishman had sex with Jennifer Paxton, and Sean Finnegan then received fellatio from Rebecca Dishman. Members of the jury, you're to consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses and charge included in count 6. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated rape, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of aggravated rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you will proceed to determine his guilt or innocence of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute attempt and aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of the attempted aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you should proceed to determine his guilt or innocence of facilitation of aggravated rape, a lesser included offense. Facilitation of aggravated rape. The essential elements necessary to constitute facilitation of felony and aggravated rape have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated rape, you will so report on your verdict form. You'll so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you should proceed to determine his guilt or innocence of rape, a lesser included offense. Right. Any person who commits the offense of rape is guilty of the crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. 2, the force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly were all defined for you in the instruction on aggravated rape. Refer to those instructions here. If you find from your proof beyond a reasonable doubt that the defendant is guilty of rape, you should so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of aggravated sexual battery, a lesser included offense. Aggravated sexual battery. A person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond the essential elements. 1, as to count 5, the defendant had intentional unlawful sexual contact with the alleged victim, in which the defendant intentionally touched the alleged victim's intimate parts or clothing covered the immediate area of the alleged victim's intimate parts. Or B, as to counts 4 and 6, the alleged victim had intentional lawful sexual contact with the defendant, in which the victim intentionally touched the defendant or any other person's intimate parts or clothing covered in the immediate area of the defendant's or any other person's intimate parts. And 2A, as to count 4, the defendant intentionally, knowingly, or recklessly used force to accomplish the act or was armed with a weapon or any article used or fashioned in a manner to lead the alleged victim reasonably to believe it to be a weapon, to wit, a baseball bat. Or B, 2B, as to count 5, the defendant intentionally, knowingly, or recklessly caused bodily injury to the alleged victim. Or, as to count 6, the defendant was aided or abetted by one or more persons and intentionally, knowingly, or recklessly used force to accomplish this act. Bodily injury, force, victim, intentionally, knowingly, recklessly were defined for you in these instructions on aggravated rape. Refer to those definitions here. Intimate parts include semen, vaginal fluid, primary genitalia area, groin, inner thigh, buttocks, or breast of a human being. Sexual conduct means the intentional touching of the alleged victims, the defendant, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim, the defendant, or any other person's intimate parts. If that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated.
there is some questions. Some people you can get it on your cell phones and Mac computers, but others you cannot. It's a YouTube thing, and some people are saying you have to have 100,000 subscribers, which I don't think that's necessarily true because I have Apple phone and I did a subscription on somebody less than 100,000. So I apologize. It's an iOS system with YouTubey thing, but wait till you get to a computer. I appreciate the request. Thank you so very much.
Sexual battery. You will also report your verdict on your verdict form. And if you have a reasonable doubt as to the defense guilt of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of attempted rape, a lesser included offense. Attempted rape. The essential elements necessary to constitute attempt and rape have previously been set out in his instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted rape, you will so report your verdict on your attempted verdict form. If you have a reasonable doubt as the defendant is guilty of attempted rape,
I'll help you.
your verdict must be not guilty as to this offense, and then you should proceed to determine the guilt or innocence of facilitation of rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and rape have previously been set out in the instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of rape, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of rape, as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of attempted aggravated sexual battery, a lesser included offense. Attempted sexual battery. The essential elements necessary to constitute attempted and aggravated sexual battery have previously been set out in the instructions.
I don't know.
Refer to those instructions here. If you find from the proof beyond reasonable doubt that the defendant is guilty of attempted aggravated sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted aggravated sexual battery, as you charge the indictment, then your verdict must be not guilty as this offense, and then you should proceed to determine his guilt or innocence of facilitation of aggravated sexual battery, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and aggravated sexual battery have previously been set out in the instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated sexual battery, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute facilitation of felony, attempted aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt or facilitation of attempted aggravated rape as charged in the indictment, then your verdict must be not guilty as this offense, and then you're to proceed to determine guilt or innocence of facilitation of attempted rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony, attempted rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted rape, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated sexual battery, a lesser included offense. Facilitation of attempted aggravated sexual battery. The essential elements necessary to constitute facilitation of a felony, attempted aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated sexual battery, you report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of attempted aggravated sexual battery as the charge in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of sexual battery, a lesser included offense.
I'm watching my little jumping spider.
Sexual battery. Any person who commits the offense of sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, as to count 5, the defendant had intentional or unlawful sexual contact with the alleged victim, in which the defendant intentionally touched the alleged victim's intimate part, or or the clothing covering the immediate area of the alleged victim's intimate parts. Or B, as accounts 4 and 6, the alleged victim had intentional unlawful sexual conduct with the defendant, which the victim intentionally touched the defendant's or any other person's intimate parts, or the clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2, force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. Force, intimate part, sexual conduct, victim, intentionally, knowingly, recklessly were defined for you in these instructions of aggravated rape and aggravated sexual battery. Refer to those definitions here. If you find from your proof a reasonable doubt that the defendant is guilty of sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as the defendant's guilty of sexual battery is charged in the indictment, then your verdict must be not guilty as to this offense. And then you'll proceed to determine his guilt for instance of attempted sexual battery, a lesser included offense. The essential elements necessary to constitute attempted sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find any proof that beyond a reasonable doubt that the defendant is guilty of attempted sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defense guilty of attempted sexual battery as charged in the indictment, then you must return a verdict of not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of sexual battery, a lesser included offense. Facilitation of sexual battery. The essential elements necessary to constitute facilitation of felony and sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond reasonable doubt that the defendant is guilty of facilitation of sexual battery, you shall report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of sexual battery is charged, then your verdict must be not guilty as to this offense. Everybody okay? Nobody need a break? Still good? Okay. Aggravated kidnapping, count 7. Any person who commits an aggravated kidnapping is guilty of a crime. 3 to the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other person's liberty. And 2, the defendant did so to facilitate the commission of aggravated rape. The essential elements necessary to constitute aggravated rape are previously set out in these instructions. A removal or confinement is fraud. Force means compulsion by the use of physical power or violence. Fraud is defined as this term is used in ordinary conversation and includes, but is not limited to deceit, trickery, misrepresentation, and subterfuge. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. The definitions of knowingly and intentionally.
Judge, was that too much for you? There.
Objectives
Came
of
back.
the conspiracy are completed, or the agreement they be completed is abandoned by the person or by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit premeditated first-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of conspiracy to commit premeditated first-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of the conspiracy to commit second-degree murder, a lesser included offense. Any person who conspires to commit second-degree murder is guilty of crime. Where you find the defendant guilty of criminal conspiracy to commit second-degree murder, the state must prove beyond a reasonable doubt the existence of the following essential elements. Excuse me. The defendant entered into agreement with one or more people to commit the offense of second-degree murder. It is not necessary that the object to be obtained of the agreement be obtained.
No
Two,
pickles.
each of the
There
parties
is a lot
to the
less.
intent to commit the
A
offense
lot of
second-degree
lesser
murder
included
should be defined
charges,
for
and
you,
I
lesser
hate them.
included offenses of
Okay,
count
I'm going to
one.
pause this so you can hear what I have to say. First of all, sneaky side, I don't know. Is anybody hearing an echo of feedback, or is it maybe on your end, beloved? Yeah, but we'll talk about it in Discord, Miss Sneaky. But um, there's a lot of lessers, and I don't know where, who, how, why they thought lesser included was a good idea. To me, it confuses the juror. I think that they're trying to make it to, well, if you don't feel that second degree manslaughter is proven, but you think that a lesser is proven, better to hit them with the lesser than let them go free. I don't know. I'm just starting my journey in criminal law. I'm getting a degree in criminal law and all that stuff, but oh my gosh, y'all, I don't like the lesser included. Not in some of these cases. In like the Karen Reed trial, that confused the jurors.
And three, each party acting for the purpose of promoting or facilitating the commission of offense of secondary murder has agreed that one or more of them would engage in conduct which constitute the offense of secondary murder. And four, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of that conspiracy. Here, intent means the person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that may be completed is abandoned by the person and by those whom the person inspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime and obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit secondary murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilty of conspiracy to commit secondary murder as charged in the indictment, then your verdict will be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of conspiracy to commit voluntary manslaughter as a lesser included offense. Any person who conspires to commit voluntary manslaughter is guilty of a crime. Where you find the defendant guilty of criminal conspiracy to commit voluntary manslaughter, the statements are proved beyond a reasonable doubt the existence of the following essential elements. One, the defendant entered into agreement with one or more people to commit the offense of voluntary manslaughter. It's not necessary that the object of the agreement be obtained. And two, each of the parties to the conspiracy had the intent to commit the offense of voluntary manslaughter, which has been defined for you in the lesser included offenses of count one. And three, each party acted for the purpose of promoting or facilitating the commission of the offense of voluntary manslaughter agreed that
Thank
one
you, Pop
or more
Sugar.
people
Bye. Y'all have fun.
the offense of voluntary manslaughter.
We
And
enjoy
four,
you.
one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is act done by one party to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, intent means a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objects of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those whom the person inspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than for silence for concealing the crime, obstructing justice in relation to it. If you find further proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit voluntary manslaughter, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit voluntary manslaughter as charged in the indictment, then your verdict must be not guilty to this offense. Count 10, conspiracy to commit aggravated rape. Any person who conspires to commit aggravated rape is guilty of a crime. Where you find the defendant guilty of criminal conspiracy to commit aggravated rape, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, defendant entered into.
Okay, guys, I got to do a little commercial break. We, or I, have partnered with As the Gavel Drops. You can, they are located in Discord. They are a fabulous place to find all you need to know about most of these cases. Oh my gosh, y'all, they are following over 500 cases. So if you like to research and you like to look things up and you like to follow people, there's about, I think, 10 or 12 of us, and other creators in the list on As the Gavel Drops, that when we go live, you can just click on one of us and watch us through As the Gavel Drops or YouTube. But this place is phenomenal. And if you love to do research and you love to dig into the law, then be a mod, because there's so many cases they need more help, y'all. And that is where I get 90%, if not more, of all of my tea on these cases. So please, the link is there. Go click on it and join their Discord group. And you can follow me and other people there at the same time. Toxic Orchid, thank you so much for partnering with me.
To an agreement with one or more people to commit the offense of aggravated rape. It's not necessary the object of the agreement be obtained. 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated rape, which has been defined for you in counts 4, 5, and 6. And 3, each party acting for the purpose of promoting, facilitating the commission of the offense of aggravated rape, agreed that one or more of them would engage in that conduct which constitutes the offense of aggravated rape. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards execution of the conspiracy. Here, for count 10, it's lesser included offenses. Intent means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct, once the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, the following: escape from the offense, distribution of proceeds of the offense, measures other than silence for consent of the crime, or obstructing justice in relation to it. If you find from the proof, beyond a reasonable doubt, that the defendant is guilty of conspiracy to commit aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit aggravated rape, as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of conspiracy to commit aggravated rape as a lesser offense. If any person conspires to commit a rape is guilty of the crime. For you to find the defendant guilty of criminal conspiracy to commit rape, the state must prove beyond a reasonable doubt the existence of the following essential elements: 1, defendant enter into agreement with one or more persons to commit the offense of rape. It's not necessary the object of that agreement be obtained or attained. 2, each of the parties to the conspiracy have the intent to commit the offense of rape, which has been defined for you in the lesser included offenses of count 4, 5, and 6. Each party acting for the purpose of promoting or facilitating the commission of rape agreed that one or more persons would engage in conduct which constitute the offense of rape. And 4, one of the parties to the conspiracy committed an overt act in purpose of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must step toward the execution of the conspiracy. Here, for count 10, it's lesser included offenses. Intent.
Who are these people who are testifying?
With respect to the nature of the conduct or the result of the conduct, with the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they may be completed.
Was he found guilty already?
Is abandoned by the person and by those whom the person conspired. The objective of the conspiracy include but not limited to escape from offense, distribution of proceeds of the offense, measures other than silence, or consent of crime or obstruction of justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit rape, as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of facilitation of conspiracy to commit rape, a lesser included offense. Any person who conspires to commit aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit aggravated sexual battery,
Okay,
that
guys,
decision will depend
I'm going to
place there, or maybe 2 or 3.
because
The court has charged the jury concerning an inference that the jury may make
some of this is repetitive, just at a lesser.
an idea what it is. For example, on the first count of premeditated first degree murder, remember I listed all those lesser included offenses. So, for example, it says only check 1, guilty of premeditated first degree murder. If you have a unanimous verdict that you cannot reach a verdict on that, then you have to consider the second one, and we go all the way down. And the last one is not guilty. That's K. and the foreperson will sign each one of those. And I've got one of those for each count, so we need to fill those out. Now, our procedure is a little bit different since this could be, not guaranteed, could be something that the jury has to do sentencing on. So what I'm going to do is just say I'm going to draw out the 4 alternates. One of the deputies is going to take the 4 alternates out, and the 4 alternates will take their jury notebook with them, and then they just leave those in my office. Nobody's going to look at them. They'll be protected for you in case you need to come back. And the reason I have 4 alternates is, and this has happened before in Tennessee, one of our original 12 gets sick, and I have to replace them, or maybe 2 or 3 of them, so I have to replace them. So I'm not willing to let the alternates go. So my 4 alternates that I keep here, this is important because we're going to probably go until Monday on this before we come back and do other stuff if we've got to do sentencing. My 4 alternates cannot discuss the case among themselves, what we've heard, what the law is, anything like that. Can't talk about that. And number 2, they cannot have any contact with the 12 jurors. They cannot come around them. They can't talk to them. And my deputies will make sure of that. So that's difficult, right?
No bathrooms with them in them.
And we'll work on the rooms at the hotel, but be prepared. They're going to keep these 4 away from the 12. And then we'll go into the next phase, and then we'll see what happens with the alternates then. Everybody understand that? Anybody got questions about it? Okay. All right. So let's see what our alternates are. My first alternate is Jordan right here. My next alternate is let me hold on to that one for a second, and I'll tell you why in just a second. My next alternate is, well, the interesting thing was about, I couldn't tell if this was a 9 or a 6. So that's the reason I'm going to wait. Well, the next number I drew was a 6. So 9 and 6, you both are alternates. Where's 9? Where's 6? Okay. All right, next alternate is 3. Okay, so everybody rise, and we'll let our alternates go out with our deputy. And you can put the jury instructions and the notebook in the office. Okay? So the alternates are excused and go with this handsome gentleman right here.
No more talking.
I've already told you that once. Don't talk about it. Twice.
No confabs allowed. No confab. That is so Brit. I love it. I
Everybody
watched
have a seat,
Make
please.
Off one too many times. Love that show, Make Off. Oh, love it.
Just
Love
never
their little
begin our
snake.
deliberations. Let me tell you a little bit about that. I'll send the verdict form back there with you. I'm going to send these exhibits back with you as well. In the event you want any of these CDs or this flash drive played for you all,
Yeah,
just knock
you
on the
should be
door and tell the officer,
quitting.
and then we'll make the accommodation for y'all to hear that again, or if you want to play, but that's your call. But you'll have the other exhibits in there. I'm not going to send back the stuff in the bags, but like pictures and things like that. I'm going to send all those back. Now saying that once y'all hit that door, y'all are now in charge. And so when you take breaks, it's up to y'all when you want to take a break. But now let's say 2 or 3 of y'all say we want to take a break and we want to go outside and smoke. Okay, 2 or 3 can go do that, but you can't go out there and talk about the case. And the 9 that are still in there can't talk about the case. We can only deliberate when all 12 of us are together. I'm probably going to let y'all work to about 5:30 or 6 tonight. If you don't have a verdict by then, I'm probably going to let you go to dinner, and then we'll start back on Monday morning. And that'll be challenging, right? Because between now and then, you can only deliberate in that room when all 12 of y'all are there. And so so that means tomorrow, you all, even if we reach something today, depending on what the punishment or if you're going to sense it, y'all cannot talk about the case tomorrow at the hotel. You can't talk about it at dinner or breakfast or lunch. The only time we can talk about the case, the evidence and the verdict is in that room. Everybody understand that? Can everybody do that for me? It's really important. Raise your hand if you can do that for me. Okay, I'm counting on y'all. This is critical that we do this correctly. I was kind of waiting for the officer. Can you see if the jury can go back in his deliberation room yet? And we'll wait just a second. Anybody got any questions about? And if you, I'm not sure it was in the instructions. If you have a question that arises that you need to ask me, all you do is write on a piece of paper, knock on the door, and give it to the officer. But understand, I can only answer questions about the law, and I gave you what the law is. So that's all I can answer. I can't answer about facts or anything like that. It's very limited about what I can answer. So if you have a question about the law, you can write it down. But understand, I'm very limited on that. So around 5 or 5:30, I'll probably bring y'all back in here if you've not reached a verdict by then and say, okay, we're going to break for the evening. We ready? Okay. Thank you all for participating in this. Somebody rise, please. Jury, follow me.
All right, let's take a bet. What time do you think they're going to come out of that room? They got to go through all those counts. I I could easily, from what I've heard, say today would be nice. I'd love for it to be today. Sensei, hush. Sorry, dog wants in, and I don't want to get up.
Thank you. Have a seat, please. If you leave the courtroom, if you can just leave your phone number with one of the officers up here so we can call you if we need you. Would y'all like to take a break and then maybe go ahead and do our witness impact statements? Go ahead and get that done, or do y'all? I'm sure you're tired. If you'd rather me wait on doing that, I'll do that.
Wow,
Whatever
that's
is easier.
new. I've not heard of that before.
Okay, I've got
To the impact
got three, and the way I do it,
waiting for the verdict.
the way I do it is I ask the family to come up here. I put them under oath. I get them to read their statement, and I found this is better to do it this way because they know exactly what they're saying, and then there's some things I can allow and not allow in victim impact statements, and so we can go ahead and take care of this before the jury comes back with a determination. So I'll do that without objection to that. But I don't want to see the first one.
So, Judge, I'm sorry to still understand this is kind of like a preview.
Wow, y'all.
Yeah, except it's really not pretty. It's what it's going to be. It's the reality of what's.
Usually the
Does that
victim
make sense?
statements
Okay.
are done
But it's for you
after
to get
innocent or guilt.
objection.
That's one reason, and the other reason is just to make them. I found writing it out makes it better. So do y'all want to try? Y'all want to try this? I think my first one I've got is it Beverly? Beverly, you want to come and read this to me? Just come up here, please, ma'am.
I'm around here, baby. Get it.
Good afternoon. How are you?
This is
Your
unusual.
right hand for me. Swear to tell the truth, the whole truth, and nothing but the truth.
Wow,
So the
y'all.
purpose of this is, I appreciate you writing for me, okay? But there's some things I can allow and not allow by law. And so I don't want to do anything to mess this up.
Yeah.
Okay, so I'll let you read this into the record, and then we'll see if anybody's got any objections, or if I suggest we leave something out. Okay? I'll give you right. Sorry. My bad. Thank you. Just have a seat right there, please, ma'am. And if you'll say your first name and last name, and spell them both. What's the way, just say, go ahead and close that door.
Okay.
Whoa.
Go ahead, ma'am.
Beverly
Jar.
Jeffers, Beverly Jeffers.
Thank you very much. If you'll read your statement.
Jar. This is unusual.
Your Honor, I wanted to thank you for allowing me to speak on behalf of our family. Our lives have forever been changed. It is always hurtful to lose someone you love, but it is a different kind of hurt and pain to lose someone you love the way our family lost Jennifer. We didn't just lose Jennifer. She was taken from us. When Jennifer went missing, we all looked all over town for her. Gail, Muriel, David, and Brittany looked on the south side of Knoxville. The rest of us took the north side. We looked for her not just for a day or two. We looked for her for months, day after day. Her grandmother who she called Mom, would call me almost every day to ask if I had seen Jennifer. It was so hard on us. We knew Jennifer wouldn't go for days and not contact me or one of us. Then on August the 6th, 2020, Patty, Jennifer's mother, received a call no mother should ever have to get. They found Jennifer. Patty was so devastated. When she called me, I couldn't understand what she was saying. Then when I finally did understand, I, like the rest of our family, went into complete shock. The most awful thing that could happen to a person and their family did happen. Jennifer was murdered. Jennifer, who was a mother, a daughter, a granddaughter, a sister, a niece, and a cousin. Her mother, Patty, didn't make it through the loss and devastation. She died with a broken heart. Before Patty passed away, she asked myself and the other ladies here with me today to promise her we would be here in court every day for her and Jennifer to show Jennifer was loved, is loved, and forever will be loved and missed. Thank you, Your Honor.
Very good. You honor Jennifer by doing that. That's okay. And you made your promise. You carried out your promise. That's what we're supposed to do, right?
Yes.
Okay, good job. Thank you. I'll take it. And right now, I don't see anything objectionable in that. but I'll talk to the attorneys. If I find anything objectionable, I'll just draw a line to it.
Okay.
Is that okay?
Yeah.
Very good. Great job.
How horrible. And
So
that's
next I have, is it Brittany?
anything objectionable? So she can't just share her heart? I guess they don't get anybody standing up saying the cursey word. Oh my gosh, y'all.
And this is Miss Payne. Okay, Miss Payne, if you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And if you'll say your first name and last name and spell them both for me.
Brittany Payne. Can you hear me good?
Yeah, you good?
Brittany Payne. BRITTANYPAYNE.
And Miss Payne, I've reviewed this. I've read it. Perfect. Very good job. You honor your friend. The only thing I feel like I should strike is down there where it says
Yes.
evil is real.
Mhm.
And I understand you feel that way. And I'm not diminishing that at all. But that may be inappropriate. And I don't want to do anything to mess this up. Okay. So I'm going to draw a line through this. So when you have the opportunity to read this in front of the jury, don't want you to read that. Okay. So will you read this one?
Yes, sir. Oh, sorry.
Oh, so
Jennifer
we're
was my first cousin,
front of the
but we grew up as sisters.
gonna-
I love Jennifer with all of my heart. Losing her has really hurt me. I can't think straight. I have nightmares. Sorry. I have nightmares. I can't sleep right. And this past week, I can't even eat right. I can't listen to songs without thinking of her. It hurts me to know that I will never see her again. I'll never hear her voice again or see her smile or hear her laugh. It absolutely kills me that I didn't get to tell her goodbye. No one will ever get these phone calls or messages ever again. Destroyed my heart. My whole world changed, turned upside down. I'll never look at this world the same again.
Thank you, ma'am. And I've noticed, I've seen you on court every day. And I know you're not here just to see me. You're here to honor your friend or your sister.
Yes.
And so that's a great thing. And you've done that. You've been successful in that. And I can't help but think that she's not pleased that her friends are here lining up for her.
Yes.
Good job. Thank you. Step down.
Thanks for the update. Continuing to pray for all his family's friends.
And next is Jennifer Paxton.
This will be Michelle, I believe it's.
Oh, I'm sorry. I just read her
Her
name.
last name, McMahon.
You're right. Where's Michelle?
You
Okay.
probably have her sign up with her name.
She did. That's right.
I like
And
this.
Michelle, if you
Joe.
state
You're
your, raise
right.
your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. If you'll have a seat and tell me
Yeah.
your first and last name and spell
It
them
is
both.
an appellate issue.
Michelle,
Never seen it done.
Michelle, McMahon, MCMAHAN.
I think he's being super careful with this case because
Okay.
this is a
And
doozy.
in these victim
And there's
impact
a lot of
statements,
appellate.
I have to be careful.
Okay.
We can't say anything that would get the jury motivated. That makes sense?
Yes,
So I'm striking, and when I do this,
Yeah,
I'm not being
because the jury
disrespectful
is
to you or your
it's
feelings at all.
I understand.
the same
Great.
jury.
So I'm striking the line that says, I feel that this directly led to her befriending the monster who sits at the defendant's table. Let's see what else I've got here.
And they're reading it into record and allowing the lawyers to to object.
And then I'm going to strike out the line that says, and I'm not saying this didn't happen, okay? Because I think this is Jennifer's mom that struggled. I think that's what you're saying. She struggled to understand how not just one, but two people, that evil could be so cruel with disregard for another human life. And so I'm going to strike that, not being disrespectful to you at all, but just making sure I don't have an issue to have to do this again. And so what's your relationship to Jennifer?
I was her mother's first cousin.
Okay. I can't say that at all, but if you'll read that to us, please, ma'am.
I'm Michelle, first cousin to Jennifer's mother, Patricia. First, I'd like to tell you about Jennifer. She was kind and loving. She cared about other people, even strangers. She grew up with a tough life, as many of us did. The difference between her and us is that she never seemed to make peace and get past the hardships of her childhood or upbringing.
Hmm.
She never knew her natural father, and partially, I think that distorted her view of what a typical family unit should be. I believe that this led to her making a series of poor decisions in her own life, including the men she chose to try to build a family with. She longed to have a typical, normal American family. She trusted too easily and too much. Jennifer's mother tried the best she knew how in raising Jen, but in her own words, she made a ton of mistakes, especially with Jennifer. Patty was desperate for Jennifer to not make the same mistakes that she had made herself, like becoming a mother at just 15 years old.
Ooh.
Because of this, she was way too hard on Jennifer.
Mm.
Again, her words. Not allowing her to have friends. She wasn't allowed to play in the neighborhood like her brothers or hang out with others after school unless it was with family. This is why Jennifer lovingly clung to her grandmother. She felt loved with her. She was allowed to be more of a child with a normal life when she was with her. So naturally, Jennifer had more of a mother-daughter relationship with her than she did with her mother. Jennifer was also a middle child and the only girl to her mother, Patricia. When Jennifer went missing, it didn't go unnoticed by her family, even though she had become part of the homeless community. Many of us searched for her for months, as well as looking at every person we passed as we went about our daily lives, hoping to spot her somewhere, as we always had in the past. Patty, like many other parents of addicts, was terrified of getting that call or knock on her door to tell her that Jennifer had overdosed and was gone. That call came in August of 2020, only it was much more horrifying than she could have imagined.
Bet.
I spent much of the time after Jennifer went missing with her mother until her passing, only 16 months later. She suffered finding out Jennifer's demise after 9 months of searching. Patty was in poor health, but was haunted by the things we were told by investigators of what those people did to her daughter. She blamed herself. She stated and questioned regularly how if she had been a better mom, or if she had tried one more time to help her, if she could have prevented what happened to Jennifer. She thought Jen fell victim because maybe she didn't feel loved enough, because she had been so hard on her in her life. Patty had nightmares every night of Jennifer crying out in pain or for mercy. She imagined Jennifer begging them to stop and let her just come home to her family. Patty continued in church looking for comfort and trying to find understanding of what led to Jennifer to get in the car. Patty died in the hospital, still crying and suffering over what happened in the Finnegan Dishman home those 4 or 5 days. Patty had battled health issues for years, but after losing a second child in such a horrifying manner, she had just given up. She was tired of regret, tired of the nightmares, the day thoughts, tired of suffering and missing her daughter, Jennifer Paxton.
I may have to take some things out,
I understand.
but I'll work on that. And, you know, it's hard to understand addiction. I worked with a drug court for about 14 years, and I came to discover that addiction is like cancer. And when you have cancer and it comes back, we don't say you didn't work hard enough in your rehabilitation. And so that's what happens with addiction. It just keeps coming back. And I hope that, not where you are faith-wise, but this is just our temporary home. That's why there's bad things that happen.
I agree.
But good things, there's good things. And Jennifer's in a lot better place.
With her mother.
Not addicted anymore, not hurt anymore, not living under a bridge.
Amen.
She's on top of the bridge, right?
Yes.
Yeah. So
I
celebrate.
love this.
Celebrate the wonderful memories that you had. And when the DA talked about her dancing, I love it.
Love
What a great memory of
Judge.
somebody dancing.
I
with
thought
her.
her body was
And
found
that's
in
what
the
she's doing.
freezer.
We're struggling through this.
I agree.
Okay.
Thank you.
I thought her body was found in a freezer.
All right, so I need to make the next exhibit.
I could be wrong. I
Jury
didn't watch
instruction.
the whole game.
Madam Court Porter, will you make that the next number exhibit? And I'll go through and edit this some more. I didn't catch everything I should have caught. And I'll show it to council before we do the victim impact statement, so y'all can look at it again. Anything else for the state I need to do?
Just for the record purposes, I brought over the laptop, and if you wanted to look at that to just ensure you're satisfied, there's nothing on it.
I'm satisfied, but I'd like you to.
We discussed it. It is a computer that's provided for the purpose of looking at CC material, so it cannot be networked. And for any files that were on it, I've deleted it and the quick access. So you would never be able to open it anyway, since the file's deleted. But you can't even see the file path name that was on there and MTB
We
recycle bins.
plan on staying around and go back to the office.
I'm going to be in the office. I could leave this here.
Okay, you can
The
leave it.
password is
If we can't figure it out, we need your phone number to call and say how to turn the thing on. Okay.
Thank you, Judge.
Anything else I can do? Okay.
Mayor.
And then I think we've still got a motion in limine in regard to the aggravators.
Judge, I misspoke. That's going to be a proposed jury instruction.
Oh, later.
Yes.
Okay. So yeah, whenever you get that to me, you don't need it right now, but sometime on it.
Yes.
Okay. All right. And so if y'all leave, just leave your phone number with one of the officers,
Ooh.
Ms. Jones, and we'll call you if we get a verdict or if we have a question. That's normally what's going to happen. I get a question next. Okay. All right. Thank y'all very much.
Thank you.
Judge.
Ew. Okay, y'all, let's do this. This girl's got to take a little lady room break. Y'all, everybody take a break. We're going to come back. I'm going to play opening statements. I haven't heard them. Okay? So I'm going to play this commercial and then I will be right back, y'all. It'll be quick. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. Well, I told you it would be quick. Oh, getting my feet up on the ottoman under the desk, getting myself all comfortable. Oh, get everything where I can reach it. Someone said, "What do I have the chopstick for?" Well, it's because that way I can reach my buttons in this position because my feet are, I have a old injury on my foot that is rearing its very ugly head and it's swelling. And I've been sitting for 12 hours a day almost. And so I'm just trying to keep my feet up to keep them from swelling. Okay, y'all. Oh, here's a note. Here's a little thing from our sponsor. I have a fabulous sponsor. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. All right, guys. So now what we're going to do is we're going to observe the opening statement.
we go back.
Evidence today from the state's witnesses, including someone who's there, including investigators. But it all comes down to the roads of three people. Sean Finnegan was getting investigated that day, initially, as what was maybe a neighborhood complaint. But what had happened to get us to this point was this defendant kidnapped Jennifer Paxton, brought her to his house here in Oak Ridge from Knox County, looked at Rebecca Dishman and said, "You want to kidnap her?" and hit her with a baseball bat across the head. He then chained her to his bed. The two of them engaged in raping her, kept her chained for days. She had to defecate in a Fireball whiskey bucket that they brought upstairs to the bedroom for her. And at some point he said he was going to kill her. And Sean Finnegan, at that point, strangled Jennifer Paxton to death. Multiple times. It took hours, perhaps, for Jennifer to actually pass, because you'll hear that Sean Finnegan would choke her and then let her go, and choke her and let her go. You'll see physical evidence from her throat, actually ligature marks from it cut open. After he finished, cleaned up the body, ordered a freezer and put that freezer in his house, wrapped up her body, and put Jennifer Paxton in the freezer. And he kept her there for 8 months until, again, that's this I hear about a body in the freezer. So we have Jennifer Paxton. You've heard a little bit about her. She was addicted to drugs. She lived in homeless camps, transient. Sometimes she was on Chapman Highway homeless camp. Sometimes she was at one near Merchants Drive. Those are both in Knox County. Sean Finnegan worked at the Pint House. That is a bar pub that is on Merchants Drive in Knox County. She engaged in prostitution. And it was something she would do to trade drugs or money for sex. She ended up coming home with Sean Finnegan. Ostensibly for that. Drugs, sex, good time. But she never left that house. You'll hear from Rebecca Dishman. She's the co-defendant in this case. You just heard me read her name on conspiracy charges, working in conjunction with him. And you'll hear she was there. She had a relationship. You'll hear her up from the stand right here tell you that she and Sean Finnegan were dating. She loved him. She was about 21 years old when they met in the fall of 2019. And by December of 2019, Jennifer Paxton was being held hostage in the same apartment where Rebecca Dishman was living with her boyfriend, Sean Finnegan. So she's 21. She moves in with Sean after meeting him on Facebook in the fall. She has what is a BDSM relationship with Sean Finnegan. If you're not familiar with that term, it is bondage, dominance, submission, sadomasochism. It is a master-servant sort of relationship. And she's into that. you'll see that she was engaged in this as his submissive, and he was the dominant. He was her master. She called him master. Mr. Finnegan is in the early 50s, 51, 52, remember that. She also calls him daddy. The power dynamic of these two individuals is very clearly master, submissive, dominant, submissive, daddy, baby girl. She's engaged in this. She participated. The state submits to you that Sean Finnegan was in control of this situation. She's there. He keeps her from having cell phone access. She doesn't have a job. She doesn't have a car she can drive. There's one there that was her aunt and uncle's. She doesn't know how to drive it. She can't leave. No job, no phone. She engages in the sexual acts with Jennifer Paxton. She is home when Jennifer Paxton's chained to the bed. And she's there when Sean Finnegan is choking her. That you'll see from the proof that Rebecca Dishman was a participant at the behest of Mr. Finnegan. You'll see that she was controlled, and eventually her dynamic with Mr. Finnegan changed from this is something I'm an active participant in to the point that she felt like she needed to get out. And she tried to get out. She went to neighbors. You'll hear from some of those. You'll hear about how she was telling them that she was getting hit, about how he was controlling of her. They saw it too. She goes and she gets a neighbor who's trying to get her some help, and it's like, okay, we're going to get you this shelter. So in August of 2020, they make arrangements to pack up her stuff, what little she has, and get out and take her to a shelter. They're going to go up in Campbell County to get away from here in Anderson County. One other person lives in this house with Sean and Rebecca, and that's Sean Finnegan's mother.
Oh, and I
Blue
just saw
showed
that.
that she was aware
That better?
that Rebecca was leaving and notified her.
I apologize, guys. The other feed we were on, I was way too loud for. So, yeah, I'm having to bounce my volume back and forth. But thank you so much for telling me, Libby. I appreciate it. Good to see you. Welcome aboard. Is this much better?
Sean comes home and realizes she is gone and confronts a neighbor. Meanwhile, Mahogany Heck, Pico, she's Mahogany Heck at the time, Pico got married. She helps Miss Dishman. And they are driving up to Anderson, or driving up from Anderson County to Campbell County. And Miss Dishman says, I got to tell you something. And at that point, Miss Dishman tells her about the kidnapping, about beating Miss Paxton with a bat, about having her chained to the bed rail for days, tells her about the choking and the killing, and tells her she's in the freezer. And that freezer is in the bedroom closet. It is in Sean Finnegan's closet. Mahogany says we have to call the police, and does that. And they report and they send them back here to Anderson County. So they are en route back here, and Mahogany calls her fiance, now husband, Colt Pico. And he calls the police. So we have, again, these roads converging. Mahogany and Rebecca are on their way to Anderson County, getting to Anderson County. Colt Pico calls 911. While he's calling 911, Sean Finnegan, all these roads converging now, is on his doorstep saying you should mind your own business, angry at him, cursing him, and you'll hear that 911 call from Mr. Pico and hear from him telling you about this incident where he's telling the police, here's what my wife is telling me, and this guy's on my doorstep. So the officers arrived. That's where we began here. And said, what's this I'm hearing about it? And he says, ain't nobody in the freezer. That's bullshit. So what happens next? From here, officers separate the two parties. Those patrol officers leave, and Rebecca is now arriving in Anderson County. And she's talking to people from the sheriff's office, and they realize this is something that happened in Oak Ridge. So she goes to Oak Ridge, and she gives a statement there, and they're like, there may be something to this here. This is quite a statement. So they put patrol on the house to look, make sure nobody's leaving, nobody's coming, going. They bring the crime task force out. They're monitoring the area, make sure nothing's happening, and they continue investigation. So we have these people at the scene of the house on 318 East Fairview in Oak Ridge, Tennessee. And then we have investigators who are doing interviews, working with Knox County to see if there's a missing person from Knox County, because this is the information that Ms. Dishman is supplying, all of the graphic details of what happened and where this girl's from. They get an identification of this woman, Jennifer Paxton, and they get a search warrant. And so they go into the house in the wee hours of the morning. It's August 6th, before dawn at this point. And they go in and look around the house. And they open that freezer. Frozen pizza and burritos. Well, that's weird. So they continue looking around the house, and they've monitored through the course of this. They've seen Sean Finnegan go out, smoke. He actually took a drive, went to a store, got some cigarettes. They have people watching him the whole time, goes back. So they look around. Sean Finnegan had taken Jennifer Paxton's frozen body and put it under his bed while the officers doing the investigating. Reassembled, put the shelves back in the freezer, and put in frozen foods. So, but officers were able, investigators were able to find her. And as is normal in an investigation, called in medical examiner's office. And you'll hear testimony from the medical examiner about the injuries that occurred to Jennifer Paxton before she died. Those blows to the head, the strangling, the wounds, bruising. You'll also hear about injuries to the body after she was deceased. Her nose had been removed. Dozens of sharp force trauma, lacerations, cuts to her body that occurred after death. You'll hear how there's freezer burn on there. She had been there for 8 months, at least since late December, early January. It is indicated from the examination that the freezer burn and stuck to the freezer. She had to
We
be
may look
cut
at that if we have
out,
time.
literally cut out on her arm and the side of her face to get her out of the freezer, to then put her frozen fetal position body under the bed. Ladies and gentlemen, at the end of the proof, the state's going to ask you to think about the proof. Think about what you heard, what you saw in this witness stand, and apply your common sense and the law is instructed by the judge to the facts of this case. And state submits to you that when you do that, it will be evident that Sean Finnegan committed first-degree premeditated murder, that he raped Jennifer Paxton. He used a baseball bat. He hit her. He caused bodily injury to her. Sean Finnegan kidnapped her, kept her chained to the bed. Sean Finnegan worked with Rebecca to do this. Sean Finnegan tampered with the evidence, freezing her, wiping her down with bleach before he put her in there and wrapping her up. You'll hear that when this body was found, it had dozens and dozens of post-mortem injuries occurred to the corpse of Jennifer Paxton. At the conclusion of the proof, you'll see that Sean Finnegan is guilty beyond a reasonable doubt of each and every count which he is charged, and we will ask you at the conclusion of the proof to return that verdict of guilty.
Thank you.
So yesterday, when we were talking about perspective, and I told you guys this was going to be difficult. And the reason is because of the events, and the situation, and what you're going to hear is most of it is related to things that happened afterwards. And so that's one thing I'm going to ask you to separate. Your job is to figure out if Mr. Finnegan is guilty of something, what he's guilty of. And so you have to be able to separate out the fantastic nature of these facts, because we're going to be talking about stuff that maybe is not in most of our lives. It's not in mine personally, generally. So it's really hard to understand things from that particular lifestyle. But this is a lifestyle that all of these folks were involved in to some degree. Restaurants, late nights, drugs, alcohol, sex, kinky sex, weird sex. It was part of what they were doing. And so I guess I'm asking you to kind of step back and think about it, even if you can't view it from the perspective of someone who does that, just realizing that they probably view the world a little bit differently than you do, and maybe they would make different decisions when faced with different issues than you would, or that I would, or anybody would, that's not involved in that type of situation, okay? And so that's all I'm asking you to do with regards to perspective, because we all come in with different perspectives. And so when we have prosecutors, they look at things through a prosecutor's lens, right? And defense attorneys look at things through defense attorney's lens. It's probably not surprising to you that I see things a little bit differently than they do, or we wouldn't be here probably. Mr. Finnegan sees things a little bit differently than they do, or we wouldn't be here probably. We're going to talk a lot about Rebecca Dishman. They want you to understand this master-servant relationship, dominant, submissive relationship. And the age difference is a big deal, right? He's in his 50s and she's in her early 20s. And I think that they're trying to present her as mentally handicapped somehow, which she pled guilty to murder, y'all. But they're trying to present her as some kind of mentally handicapped person because she's the witness now. And the story comes from her. Nobody else was there. Sean and Rebecca Dishman. And Sean's mother, who he was taking care of, who was in hospice care. So who can tell the story, right? She can. So all of the facts that you just heard, all of the stuff that happened to Jennifer Paxton is straight from Rebecca Dishman's mouth. And so all I'm really asking you to do is I'm asking you to do the same thing they're asking you to do, basically. And that's to just pay attention to the evidence. And you need to ask yourself, how does that apply to what happened, to the versions of what happened, okay? Because Rebecca Dishman also gave multiple versions of what happened. Mr. Finnegan gave a statement too, and I have to assume that you're probably going to hear it, that the state's going to play it. So I mean, you'll hear what he says happened too. And from my perspective, the physical evidence and the all of the evidence, the timing is more consistent with his version of events than hers. Mr. Finnegan worked full time. He worked at a restaurant. He's a very simple, straightforward kind of dude. I guess he goes to work and he works long shifts. He doesn't get home till 3 or 4 in the morning. He supported himself, his mother, and Rebecca Dishman while she lived there, and a couple other people who he supported when they needed help and asked him for money or drugs or whatever. It's the lifestyle that they lived. He was giving people places to crash. So I'd like to present this in a different way. We have this age difference, and our natural reaction, it's my natural reaction, okay, to that when we see this age difference and they're poor, that the old man must be taking advantage of the young girl for sexual favors or for whatever. If he were Leonardo DiCaprio, we would say that the 21-year-old is taking advantage of him for his money. Maybe, right? I mean, the point is it's the perspective. And you have to look at who's in control the whole entire time. For 9 months, that body's in that freezer. She's alone at that house most of the time. Most of the time. Not locked. I mean, I'm talking about Rebecca Dishman, the one who tells the story of what happened there. The one who told the story that the state bases their entire case upon. Her version of the events. Okay. She was the one who was there alone. With Jennifer Paxton, he was at work. He worked in the evenings. So for 9 months, a body in the freezer, or days supposedly chained to a bed, and all of these type of things, I mean, you better make them prove that stuff, because that comes out of her mouth, all of those events. And you also need to think about who was into this, who would want these type of things, who would benefit the most from this type of thing, who would have some sort of motive to kill the prostitute that Mr. Finnegan brought home. You're going to hear that they had threesomes before. This wasn't the first time that someone had come home. You're going to see texts where she's saying, I want to have sex with a girl. It's time, I want to have sex with, it's time or whatever. I mean, this was stuff that they did, all right? So who had motive to kill? Mr. Finnegan goes to work and supports everybody and likes sex. And smokes pot, he's an old burnout. Okay, like a 6th grade education.
Oh, don't. No.
She lets it slip to her neighbor,
No.
or she starts talking to her neighbor. Maybe she's getting ready to leave or something. I don't know.
Okay, guys.
But she starts talking to a neighbor who's been hanging out
Wait
with
a minute.
her. Stays over there. They're all friends. They hang out.
I tell you how they sleep not very well. Guys, I feel sorry for these people that have to defend these people. But I'm going to say this. This is horrid. Okay? And I'm not going to share my personal life experiences right now, but I can relate to some of this. And I'm going to tell you right now, this is hard. It is hard. But please understand that he's a massive manipulator. And we're going to hear a lot of things, and it's going to be easy to judge both sides of the party. But I'm going to guarantee you what they went through, what these girls went through, and what he did to them, they don't deserve it.
She's being abused all this time. That's what they want to say. She's being abused all this time. No reports, nobody. This friend's not going to try to get her out or help her or any of this kind of stuff. So finally, this one day, she lets it slip to a friend or starts talking to her about, well, he's just being abusive now and stuff. And maybe the friend's had enough of hearing it or something because she's not doing anything or she's not seeing any evidence of it, or I don't know what. We're probably going to hear from her. We can ask her, I guess. But that day, she tells her, and then what happened? It's just now she's got to go with something, doesn't she? She left the house. She's got her stuff. She's got a friend. And from the very beginning, she knew who would get blamed. It's his house. He's a 51-year-old man who's there taking care of his mother. She's a 21-year-old girl who basically gets whatever she wants to use her sex. And who do you think is going to get blamed? Who do you think that she thought was going to get blamed? Who do you think he thought was going to get blamed? So I think at the end of the proof, you're going to find him guilty of some things. I mean, if they prove it, then you should, right? But there are two different things. He gave a statement to the police. She gave several statements to the police. She's going to get some more statements in here. But he also just gave another statement that she did not give. And that's when I stood up for him just a minute ago and I said, not guilty. For some reason, the state's given her a plea. She had lawyers too, right? She had lawyers too. And she had good lawyers. I don't think that they would if she was mentally incapacitated, I don't believe they would let her plead guilty to a first-degree murder. If they didn't think she was mentally culpable, I don't believe they would have let her plead guilty to a first-degree murder. And if she wasn't guilty, I don't believe she would have pled guilty to a first-degree murder. In fact, during the soliloquy of pleading guilty, well, most of the time the judge asks, are you pleading guilty because you actually are guilty? And they have to say yes. Okay? He pled not guilty. And we're here. They were both charged with the same stuff. She was also facing the death penalty. So who's in control? She goes out, she reports that he's got a body. She tells totally different stuff. That she was being tortured for like a month, chained to the bed, all these different things, that he's ejaculating on the body and he's opening up the freezer and he's doing all these things. That's all from her. There's literally zero evidence that proves any of that stuff. That's from her. So when the state says you're going to hear, they're right. You're going to hear, and you're going to hear it from Rebecca Dishman, and that's it. That's it. There's no denying something horrible happened. Something horrible. There's a reason why there are cameras in the courtroom and the media's here, though. Is because this is this kind of thing that people podcast about. I assume there's some podcasters in here.
Oh,
This kind of thing people write
really?
books about, right? Because it's fantastic. It's sensational. It's you've got a body in the freezer. I mean, it's got all
Okay, I need to make this clear. I got to make this clear. Just because you think he isn't guilty doesn't mean he isn't anything. Okay, first of all, everybody hates prosecutors. They know it. They know it's a part of their job. They know they're going to get it. It is the way it is. Okay, everybody hates prosecutors. Okay, that's just life for the prosecutor. It really is, and I feel bad for the prosecutor in that sense. However, you guys, it, I am not here sensationalizing this. I want everybody to understand that. And it pisses me off that he says that. Now, there may be some people out there who may be sensationalizing it, but I'm going to say this as generically as I can. I can relate to some of these experiences, and I'm doing it for educational. I want people to know. Young women need to know what lurks behind closed doors. These young women need to understand that these predators are out there. And yes, and part of the problem though was, and I'm not saying the girl deserved anything. Understand, I am far from saying that.
Can you get customers from here?
Can you give me a chance to mute?
I'm just asking.
Yes.
Alrighty, thank you.
So what I'm saying is that people need to know this stuff goes on to protect those who cannot protect themselves. And I educated my daughter very well on a lot of this stuff because I did not want my child to go off to college and not be aware of what could happen to her. Y'all, teach your daughters, teach
them well. I'm kid you not, y'all. This is not something that we can educate people on without showing this. I know I'm going on a rant, but I'm not here sensationalizing. In fact, I demonetized this. So you can't say that about me. Other people, probably.
Hallmarks of a movie, doesn't it? And so when you're trying to paint a picture of someone who would do this sort of thing, we've seen so many movies. I mean, I've seen so many movies. I've seen so many television shows. And what's the profile of someone who would do something? You know, a middle-aged white dude, right? And he's sitting over here, a middle-aged white dude, and it fits the profile. And it's real easy to point the finger. But you have to consider where the evidence comes in. We talked about garbage in and garbage out. If you base your decisions and you base your interpretation on evidence that comes from a terrible source, or which would be questionable whether or not it's evidence, right? Because it's just something that's being offered from a terrible source or an unworthy source or an unbelievable source. That if you're basing your opinion on information that's coming from a bad source, then the conclusion that you reach is necessarily bad. That's the concept, that's the idea. So you have to think about where this information is coming from. You have to make them do their job. I mean, that's your job. That's your job, is to make them do their job. Just because they think it's true doesn't make it true, okay? Just because they say it's true doesn't make it true. Just because they say the evidence to us looks this way doesn't mean that's the way it is. It means that's the way it looks to them. And it fits in with the scenario that was presented by Rebecca Dishman. But don't let them think that she's a victim here. That she's the victim, she's coming in here, he was pulling all the strings, she's this puppet, and she's trapped at the house, and she can't leave, and she wasn't. She was not trapped at the house. That's where she lived, because he housed her, and fed her, and provided her a phone, and probably glasses, and probably food, and probably every other thing, because she didn't have a job. She didn't work. I think you're going to hear her talk about she was trying to get disability. And we'll see if we'll talk about that, because she kind of knew the process. And that's also something that someone that has mental capacity issues probably wouldn't understand the process. It's not a simple process to get disability. I don't know if anybody's ever gone through that process or not.
No.
You're going to hear that she has some depression and she's
no idea.
got some learning disabilities.
Young girls don't
learning
have
disabilities do
idea.
not equate to a lack of intelligence. I went to law school with someone that was toward the top of my class, and she was dyslexic. It doesn't equate. So depression. Half the lawyers and doctors and professionals I know have depression, have OCD, have ADHD. It doesn't equate to lack of intelligence, okay? So don't let them do that. Don't let them put her up here and pretend like she's a victim when she just pled guilty to all of these charges. Listen to what she said.
She was guilty to a point, but she also was a victim. And that's one thing I hate about the system, because let's think about this for a second, y'all. I want to talk about this. Are you okay with that? The thing about being a victim and a perpetrator is it gets to the point that you have no other choice, no other choice than to give in, surrender, and do what you're told. There comes a point you are so brainwashed that you have zero hope, and thus you you just do it. You just do it. And people don't get it. They don't have a clue. It's not that the girl wanted to do it, but it got to the point that she probably felt in her own world and in the place that she was in that if she didn't do it, then she could die. and it was her or somebody else, and she's going to pick herself. And I'm not saying it's right, but that's reality in these situations. So I understand. I don't understand why the law doesn't understand this, but it's kind of like fight and die, surrender and live. Which do you choose? Surrender and live. That's it. In my humble opinion. Oh, by the way, look up in the top right-hand corner. I am a Joe, in my humble opinion, which I say a lot. And I know it says I'm Ho. But what do y'all think about that? Especially depression, whatnot, will make everything so bleak too. More inclined to fall into the negative pattern of thinking about themselves to boot. That pickle knits, that's good. And the other thing also is drugs, alcohol, all of that stuff. It all adds into this. Every bit of it. Every bit of it. So I'm not mad. Don't get mad at the defense lawyer. Honestly, he has to do this. He may go home and throw up every night after meeting with his client. We don't know. But I guarantee you, this is not easy for them. This case is beyond what most of them deal with. And he's doing his job, fighting for his defendant to the best of his ability, and then he can go home and take care of himself. It's horrible. And I'm sure this is going to give him PTSD.
Says, see if it makes any sense, and then realize that from the beginning, she started telling the story. They bought the story. All the stuff starts to line up with the story she told because she knows all the details. She was there. She knows amazing details. She knows the details about this woman's body, where the cuts are, all her tattoos, that they're naming kids here. She knows all these things. Well, I think she's going to testify to all that stuff. But she knows amazing details. You know why? Because she spent all the time with her. She's the one who was doing all this stuff. She is the one who was interested in any of this kind of stuff. She's a cutter. She talks about cutting. She's got depression, where all the cuts on the body, everything relates back to Rebecca Dishman. She's the one that's at the house. Then she goes out and she blames the one person who they know, who she knows she can blame. And what's he supposed to do? He helps her. And when he goes to the police, when they come and get him, of course he's scared. Of course he denies it. But once he goes in there, he goes, I know why you came and got me. I helped her cover it up. That's the first thing. That's his first reaction. And if they play his statement, you'll see it, right? You'll see the way he reacts to the police officer. And he's really kind of straightforward with them. And they're berating him. They're coming after him. They did not treat her like that. They treated her like a victim. And I think we'll hear that from the officers too, which is probably not wrong, because she came in and made some accusations they had to follow up. I mean, they weren't acting wrongly by treating her like a victim, because it sure seemed like she was a victim. And then the longer she talked and the more it changed, and then the details started changing, and then you can see the wheels turning in the officers, because they're good. They know what they're doing. And they say their wheels turning and say, well, she's more involved, right? Because they eventually charged her with the same crimes. And now they need her to make their case, which should be problematic. Should be problematic. Because if they had enough evidence to prove what they're claiming against him without her, they wouldn't put her on the stand. Okay? So all I'm asking is pay attention to the power, to actual dynamic, the actual power dynamic, okay? Servant and master, or whatever, servant and master, dominant, all that kind of stuff. We're going to see texts. She initiates most conversations. Hey, I'm thinking about you. It's all sexting and like, it's just kind of gross. We're going to go through it, okay? And almost always the conversation ends with, baby, I got to go. I'm getting busy. I'm at work. And she's texting from her friend's phone, Mahogany, all this stuff. who's going to come in and say, you know, I guess that she was abused. I don't know what she's going to do. We'll see what she says, but I mean, you got to look at all of it. You can't just take the narrative that's laid out there. It's too easy. It's too easy. And I told you, this is not easy. It's not supposed to be easy. You're supposed to be able to separate out the reality from the narrative, right? This isn't, y'all are not writing news articles. It's not a narrative where you have to tell this linear story. They kind of do, because their job is to tell the story. And it's a hard job, and they've got to come and they've got to try to do it. But it doesn't mean they can't. And your job is to make sure that either they can or they can't, but you got to make sure that they do. Because the more we allow the state, well, the lower we take the burden, we're just notching away at our individual rights. We're just notching away at them. We have to hold them to our burden. That's what defense attorneys do, right? We wake up every day and we try to defend the Constitution as best we can. That's ideally what we're doing, because we have to defend people who are charged with crimes in order to do that, right? And so then we come in here and our job is to make them do their job, because that makes them better. That makes the police better. That makes the attorneys better, the prosecutors better. It makes the system better. And the system is you. Y'all are what makes this work. And the way that you make this work is you hold them to their burden. You don't just take them on their word. And you don't just take their narrative as the truth because that's the way they see it, right? We're not on their team. We're all citizens of this state, and they represent the state of Tennessee. They represent me just like they represent you guys. They represent they prosecute for the state of Tennessee. But they're humans just like I am, and they see things a certain way. And if you're a prosecutor, you see things like a prosecutor. If you are a police officer, you see things like a police officer, because that's your experience. That's your life experience. I'm asking you guys to step out of whatever your life experience is, because you're going to be dealing with stuff that I think is probably not a part of your life experience. So don't jump to conclusions just because of the awe factor, because this is a shock and awe campaign. All right, they're going to show you disgusting things. Most of it happened after the fact. And what you're really here to determine is what happened before. What happened? How did she die? Who intended to kill her?
How are you?
Right?
You hear from the
Who intended to kill her?
So excited.
Who intended to kidnap her?
Thank you.
If there's a kidnapping.
Everybody,
Right?
please remember the
Who intended any of it?
Thank you.
That's what you're here to determine.
We have spicy
Because if you
cookies.
can't determine
We'll do.
that,
We'll do. I love
then he's
spicy
not guilty,
cookies in the lunch.
right? He's not guilty. He's presumed innocent. That he's presumed innocent. Beyond a reasonable doubt means that if there is a doubt, he gets the benefit of that doubt. Literally the benefit of the doubt. You've got to keep that in mind, because we're about to hear a bunch of crazy stuff. So please, just pay attention. Pay attention. Pay attention. And every time that there's evidence here, and there's scientific evidence, or there's something that's being introduced, ask yourself, does this evidence support what she said? Or does it support more of what he said? Or does it support any of it, right? Does it support any of it enough to be beyond a reasonable doubt for anything? That's the first thing. But this is almost like a he said, she said situation to some degree when you're trying to determine what actually happened in there. Because I think that there's not going to be a lot of argument about some of the things that happened afterwards. There's definitely going to be argument about some of the other things, but he gave a statement and he admits to things, and you can take them for what they are, and you can determine whether or not it proves beyond a reasonable doubt, but we're leaving that up to you guys. He did not plead guilty to first-degree murder. He did not plead guilty to kidnapping. He did not plead guilty to aggravated kidnapping. He did not plead guilty to anything on here. So anything that you want to find him guilty of, you're going to have to find him guilty. And you're going to have to find him guilty because they proved it. That's the only way you can do it. It's the only way you can do it. And that's all I'm asking.
Be hard, y'all.
It's real straightforward.
Really.
I'm not going to try to pull the wool over your eyes. I'm not going to tap dance up here. But my job is to poke holes in what they claim supports
No,
her
this
story.
is opening statements
And so that's what I'm talking
ADHD,
And we
because
need to
a
pay
lot of
attention
some
to
of us
see
have not
what they
heard
put in
them.
here actually.
Okay, let me catch some of y'all up. We are in a verdict watch. In this case, on a Saturday. I know, right? Sunday they will be off, but they have also done the victim statement run throughs because they're going to exclude some of the statements as to not to emotionally taint the jury. And then, so now we're just waiting for the verdict. So we are on verdict watch, but also I need to go back and forth between the two. Also, though, I didn't hear the opening statements, and so we're watching the opening statements. We are going to, if they're, I don't know if they're going to be back or not today, but I have a documentary we're going to watch on this from Court TV. It does get a little bit gruesome and very explicit. So, anyway, yep. So let's keep watching this.
Supports their story. Because if there's questions on responsibility, if there's questions on culpability, if there's questions on who wanted this to happen, if there's questions on who needed this to happen, if there's questions on who had the motive to make this happen, those are serious questions when we're talking about putting somebody to death. Those are serious questions, guys. There's not a more important case that you could sit on as a juror. There's not. There's just not. First-degree murder is the top charge in this state. And every time there's a first-degree murder jury, I say the same thing. I try to. But you guys are doing the most important thing you could possibly do as a juror in the country. This is the top count anybody can face, and he's facing the top penalty anybody can face if he's convicted. Your job is to do your job. And I would never ask anybody to do more than their job. But you need to understand what your job is. And what your job is not to just kind of observe and take it all in. Or your job is to literally sit there and critically judge every single thing that comes in. And it's a difficult thing because it's a difficult thing for me. I'm sitting there and I've been doing this a long time, and it's difficult to think about all the different facts. There's a lot of stuff to pay attention to. So the real simple question is, how does this
I know I
prove
haven't either.
what they're claiming happened? That's the question. Who's actually in control? The person that's testifying here who's still holding control basically over whether or not he lives or dies, or the man sitting over there at the desk that says, I'm not guilty. At the end, I'm going to ask you to find him not guilty of first-degree murder. I'm going to ask you to find him not guilty of kidnapping. I'm going to ask you to find him not guilty of these underlying crimes that could even lead you to a death penalty determination, because he's not guilty of this. And I'm going to ask you to find him not guilty of those things.
He did a good opening. Both of them did.
The call came in as a boy not breathing and felt cold to the
Okay, guys. Take a breath, everybody. Let's take a quick breath. How do you like my little IMHO up top? I'm having fun in Canva. There's the darker version. There's the light version. Let's take a little breather. Let's get some stretches. Everybody stretch. Can you stretch? Yeah, this is heavy. So I believe in taking little breaks. I believe in clearing the mind for a moment. Oh, excuse me. Oh, I keep forgetting. I'm continuing this through the end of the month. Well, guys, it's that time. We need a logo, we need merch, and a website. So I decided to have a competition. The person who creates the winning logo
logo will get a t-shirt, hat, and a $50 gift card. And the logo will be featured on everything that we have: Facebook, YouTube, Twitter, Twitch, the website, my email, all the merch. So if you're interested, deadline's August 15th. The winner will be announced on the 1st of September. Thank you so much and good luck. Yes, good luck, everybody. Yep. Okay, now I'm going to share this. This, guys, I am going to say is very difficult. This is going to be very explicit. This is going to be a challenge to listen to. But, well, the deadline was the 15th, but we only got one entry. So I'm extending it to the end of the month. Yep, to the end of the month. I know, I just haven't gone back. That's why I said we're extending it till the end of the month. See the IMHO up there with all those different colors? All the colors in the backdrop behind me are welcome. Well, thank you. This was a garage sale find years and years ago. I love it. It's one of my favorites. You'll see it on me a lot. I don't have an extensive wardrobe, so I wear black a lot. Well, and when I interpret, I wear black a lot. Back a lot. That sounded funny. But these colors in my background, which is a really vast array of colors to choose from. Somebody asked about that. So anyway, now we're going to get into this next part. And it is not fun, y'all, but needs to be watched. So, let me know.
Oak Ridge, Tennessee is a relatively small community of about 30,000 in the eastern part of the state near Knoxville. Oak Ridge was built under a cloak of secrecy by the United States government during World War II as a major site of the Manhattan Project, the massive wartime effort that produced the world's first atomic weapon. And
I know ADHD when I do interpreting. And when I was in college for 4 years for interpreting, every day was black. And my mom finally said, girl, she didn't say that. She goes, honey, I really wish you would put some color in your closet. And I'm like, my profession requires it. Took a while for me to get back into color.
Prosecutors say there was another fatal secret being kept in Oak Ridge in December of 2019. This man, Sean Finnegan, along with his much younger fiancée, Rebecca Dishman, abducted a young woman named Jennifer Paxton. And while in captivity, they allegedly chained her up, sexually abused and tortured her over the course of weeks. Eventually, she was murdered and mutilated, dismembered, and placed into a stand-up freezer. The darkness of this tale is extreme. The allegations absolutely horrid. But Rebecca Dishman is telling the jury everything, details you would only expect to hear in the most vile horror movie. But it's real. And tonight, we'll let you hear the story as our experts break down how and why a human would ever engage in such unspeakable conduct as we investigate the tragic death of Jennifer Paxton.
I'm Vinny
Okay,
Politan.
guys.
Thanks for joining us tonight here on Closing Arguments. This is a warning ahead of time. This next hour is going to be
that better?
intense. Absolutely intense. You're going to hear things that maybe you never thought you were going to hear, but it's the reality of what's happening. Now, in the years here at Court TV, we've come across a lot of horrible people. Shonda Vander Ark, she was a horrible person.
Absolutely horrible person. Tortured her own special needs son. Directed her other son to torture him, and he ended up dying, and she's in prison for the rest of her life. She's a horrible, horrible person. You saw that trial here on Court TV, and you understand the nature of who she was and what she did. Taylor Shabusiness, another name we talk about here on Court TV, out of Green Bay. Evil person. Absolutely evil. Like, no feeling at all towards other human beings. She's been convicted as well for what she did, preying upon a man, engaging in sexual conduct, and then beheading him and leaving his head in a bucket in the basement of his mom's home. I mean, evil. Tonight we're going to learn about Sean Finnegan, and he may be even worse. This man may be even worse than Taylor Shabusiness, Shonda Vander Ark. At least, it's tough. It's tough to measure depravity, right? To compare it. But when you hear it, you'll be the judge of all of this. And Sean Finnegan engaged in this conduct with someone, his much younger fiancée, Rebecca Dishman, and she is the one who took the deal. She is the one who is telling their story inside of a courtroom. And it's a tough story. There's a victim, Jennifer Paxton is her name, and what she endured is difficult to fathom that this actually happened, but it did. So again, I gave you the warning. I'm going to play a big part of her testimony right now so you understand exactly what we're talking about, but we're not going to leave it there. Then we're going to bring in some experts to analyze this, to try to understand this and figure out where it all comes from. So with the warning, let's take a listen to the testimony of Rebecca Dishman telling the story of what she and Sean Finnegan did to Jennifer Paxton.
Could you tell us about what happened when Jennifer came in?
She came in and I was putting the bed up and I was confused because I didn't.
Okay, warning. If you have minors in the room or anyone in the room that can be triggered by any, and I'm not monetized, so I can say sexual content whatsoever, warning, get them out of the room now.
I didn't know the woman, and Sean later came in and introduced us together. She made breakfast and asked to take a shower, and once she went to go take a shower, Sean asked me, "Do you want to kidnap her?" She ate breakfast and we were talking, and after she ate breakfast, he walked her over towards the back door and was showing her a baseball bat. And then he started hitting her over the head. And I went into shock and he yelled at me to go upstairs. He told me to clean up the blood, and he was disgrading her. He ripped her pants down and was screaming at her and said,
So they just speak up some more, a little louder, okay? A little closer to the microphone.
He said, "Why don't you shave?" And she started crying, and he just spat on her and was really aggressive towards her. He forced her to perform oral sex on him, and I was forced to watch.
And so forgive me for being very overt with this, but you say he forced her to perform oral sex. Could you tell us where his penis is?
He put his penis in her mouth and ripped her clothes.
And she's in the floor next to the bed.
Yes.
Where are you?
I was crouched beside him.
And how long did that continue?
Until he got angry and pulled my shirt down and made me finish.
And what do you mean by he made you finish?
He wasn't satisfied with her and he made me perform oral on him.
Were there anything else that he did sexually at any point to Miss Paxton?
He forced my adult toys inside of her and forced his fingers on her and forced me to watch. And also, at one point, she was on the floor and he was behind me and he forced me to climax over her. I couldn't climax until he forced me to climax.
But that does mean
Yes.
that you are participating. And when you say he forced you to climax, what do you mean by that?
He physically, aggressively rubbed me until I climaxed.
Okay, so he is touching you while you're over her.
Yes.
If we have the picture of that. And what did he do at your climax?
She was revolted by it and she said I was gonna throw up and he slapped her across the face and I just shut down.
Did Miss Paxton ask to leave?
Yes.
What could you do about that?
I told her that I wish I could let her leave, but I didn't have any way of letting her go, and it really upset me.
Did she ever tell Mr. Finnegan she needed to leave or wanted to leave?
Yes.
What was his reaction?
He told her that as he was killing her, that she wasn't going anywhere, that she was going to die.
So when you say he said told her you're going to die,
Yes.
what did she do?
She started crying.
And what did he do?
He just kicked her and spat on her and was really aggressive.
Did he any time follow through on telling her she had to die?
He did this as he was strangling her. As he was strangling her, I was cleaning up the blood that was left over in the shower. And at one point, he screamed at me to get in the bedroom, that I was taking too long. And I came in and he told me to lock the door. And as I walked in, he was straddled over her, strangled.
She pled guilty, but I don't know what her consequences were. If anybody knows, let me know. I'm going to try and find out.
Her with a shoestring and told me to help him, and I just shut down and sat on the bed and just gave up, essentially.
How long did this go on?
For hours.
Could you describe for us specifically what was going on in the course if you say this was hours?
He would start and stop, take breaks in between.
What finally concluded this episode?
He went to empty the ashtray and she was taking her last breath, and I got on my hands and knees and told her goodbye because I knew she was dying. And he came back inside and slapped me across the face.
There are more details of this that we will show you and play for you during the course of this hour. But this really sort of outlines a big part of what happened here to Jennifer Paxton, but there are more details that get even more depraved that we'll get into.
Okay, I got it. Rebecca Dishman, 25, pled guilty to one count of first-degree murder in the death of the 36-year-old Jennifer Gail Paxton. She was sentenced to life in prison for the murder and an additional 50 years to be served 100% on 2 counts of art of a child from a subsequent investigation. She is serving life sentence. She will plus 50. She will never get out. So she has nothing to lose by telling the truth at this point. Is everybody okay?
But let me bring in our experts who are going to help walk us through all of this. Joining me tonight, clinical and forensic neuropsychologist, associate professor at Pepperdine University, and author of the book, The New Rules of Attachment, Dr. Judy Ho is with us. Retired FBI special agent Bobby Chacon is with us. And finally, psychotherapist and author of the book, The Minds of Mass Killers, Understanding and Interpreting the Pathway to Violence, Siobhan Scott is with us as well. Thank you, everyone, for being here. I just want to start with initial reactions to what we're hearing from Rebecca Dishman, from your different perspectives. I'll begin with you, Dr. Judy Ho.
Well, Vinny, that was definitely difficult to watch. And Rebecca seemed like there was just no emotion attached at all to her testimony. I'm not really sure if I could see if that was just a freeze response or if maybe she doesn't have a ton of remorse, but notice that she used a lot of language which deferred a lot of the blame onto Sean. And there were a couple times when the attorney who was examining her said, well, you were an active participator, though. There's a couple of times there were questions like that because she seemed to make it sound like she was just forced the entire time and she didn't want to have anything to do with it, and that there was some shred of humanity she exhibited towards Jennifer. But I'm not totally sure that I buy that because it just sounds like there was so much horrible, terrible torture throughout the days that Jennifer was alive and in their custody. And I can't imagine that it was just her being forced completely the entire time. And I think that that's what the attorney was trying to get to, is how much of this was also an active participation on your part.
Bobby Chacon, I know you've seen a lot in your career. What are your initial thoughts about this case?
Well, I was thinking the same thing as Judy was. I think we know what happened. We know what she's telling us is the truth. We don't know what her level of participation was. And that's always the difficult portion of this case. You kind of know what the defendant's role was, but you really don't know. You don't know if the victim is downplaying their own role, is having problems just admitting it publicly, or what. So, that's the most difficult thing, but it's less of a concern. We need to know what this defendant did. He's the one on trial. But I did see some of the same mannerisms in her. Like there are people that I know that witness things like this that actually physically vomited because they couldn't bear to witness something like this being done to someone else in their presence. And this witness did not have that reaction. So we're not really sure what her level of participation was.
Siobhan Scott, what's your...
Okay, we cannot gauge somebody else's... Okay, I'm trying. We cannot gauge somebody else's response to witnessing something this horrific by anybody else's. You guys have no idea what I've dealt with in my life, and you have no idea what I deal with people in ministry. And I have seen the worst. I have heard the worst. And any psychologist, anybody in their right mind says you cannot gauge because everybody's life experience is different and they're going to handle it differently. So that comment really irritates me just a wee bit.
What are your initial thoughts as you hear this description of what Rebecca Dishman is saying happened to Jennifer Paxton?
I think Rebecca, I wonder if that part of it, that her words indicate that she didn't see herself as a participant. No. There's a difference between a willing participant and somebody who feels that they are an unwilling, meaning they have been groomed and conditioned, beaten and abused to the point that emotionally they don't feel that they are in control of their self, their environment, or what they can and can't do. So in her mind, she had no choice, and she's not a willing, meaning she's not going out there looking to do it. She herself feels like she was forced, not, and forced doesn't always include physical, emotionally forced. I believe that's where
And what Sean Finnegan was doing.
Yeah, I was able to watch several hours of her testimony today. And, she struck me as very childlike, somewhat cognitively slow. She's me as very childlike, somewhat cognitively slow. She's not a terribly bright person and very, very dependent. I think often in these cases where you have a male perpetrator and a female who seems to be the accomplice, there's a tremendous dependency factor going on there. It's almost like the woman will do anything for love, anything to be attached to him, which of course is a trauma bond. And we did hear about the abuse that she suffered from him, being cut with box cutters, burned with a blowtorch, chained up, so there's layers and layers of what's gone on here. And I'm very curious about what else will come out.
Dr. Judy Ho, what did you think of his reaction as she is testifying, him inside that courtroom?
I think he probably was advised by his counsel to maintain a neutral expression. He was taking notes. He was clearly very attentive. I did not see any sign of remorse, any sign of emotionality whatsoever. Sometimes you do in defendants. Sometimes they start weeping, they start sobbing, they start looking sad, they start wrinkling their face as if they're having some kind of an emotional distaste from hearing the perspective of what they did from someone else who was there to witness it. We didn't really notice any of that in that clip. I don't think I'm surprised by that, because obviously if this is a person who has normal range, empathy and morality and emotionality, he would not have been able to do this. So I think that lends less to the argument that maybe this was just for example, a psychotic break for him, a once in a lifetime thing. This may be a long time pattern that this person has exhibited for a very, very long period of time.
We're going to listen to more testimony, more of this depravity that was engaged in. I mean, this is tough stuff, but we're going to play more of it, and our experts are going to stay with us to help us through all of this. We'll do that, plus coming up next hour. Tonight on Vinnie Politan Investigates, Maya Miliete disappeared on January 7th, 2021. Her body has never been found, but her husband, Larry, has been charged with her murder. Now, we return to Maya's neighborhood and speak with her family.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in a discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central. Only on Court TV.
Hit her with a baseball bat across the head.
Okay, how are y'all doing? This is a check-in. Let's see. And after Karen Reed, Ashley Beneful, I'm overthinking again. I want to apologize to everyone. Don't apologize, Pickles. We all have a right to our opinions, and we all come from different places, different experiences in life. And there'll be times that you and I may not agree, and that's okay not to agree. I'd rather us politely express what we're thinking and how we're feeling, and have a little disagreement, because that's how we learn. That's fair, Ada. I'm sorry. I'm trying to process in my brain. It's partly because I've been shut down person and not seeing to others the way I thought I did. Yeah. And it's okay. I'm usually the person that gives people the benefit of the doubt because I'm an idiot. Yeah. And don't be disappointed in yourself. Don't be disappointed. You are who you are. You where you are for where you are is where you are. We all learn and grow. We all go through things. We appreciate you and your views. Definitely give yourself some grace. I'm speaking from my personal experience. You can speak from yours. And in between, people will connect. It's okay. We are all loved and appreciated here. Respectfully done. Okay? You're more than welcome to speak. It's okay. And it's okay if we have different experiences.
He then chained her to his bed. The two of them engaged in raping her, kept her chained for days. She had to defecate in a Fireball whiskey bucket that they brought upstairs to the bedroom for her. After he finished, cleaned up the body, ordered a freezer and put that freezer in his house, wrapped up her body, and put Jennifer Paxton in the freezer. And he kept her there for 8 months.
Unbelievable story inside this house of horrors. Still with us are our special guests, our experts looking at this case tonight, Dr. Judy Ho, Bobby Chacon, and Siobhan Scott. Bobby, to me, it seems like this is a case where, yes, you've got this powerful testimony from the co-conspirator in all of this, but you also have, I believe, a house full of potential forensic evidence.
You do, and they marry up well, right? I mean, that's the home run that a prosecutor wants. You want a physical victim on the stand that can testify and corroborate the physical evidence you find at the scene. In this case, the defendant's home. So it's really going to be hard for him I can't fathom how they're going to try to explain that away. I think this is more likely a trial where they're just trying to keep him off the death penalty and out of the electric chair. So I think that this is really the combination that's really hard. You have a bunch of horrific physical forensic evidence inside that house, and now you have a witness from inside that house testifying to what all that means. And that's a really good combination for a prosecutor to have.
Wait a minute. We got to switch. We got something going on in trial. Okay, play. Oh, let me make sure volume's all the way up. I knew he had pink on. We'll just do this. Yeah, I knew he had a pink jacket on. Okay, let's play. I may have to gain this up some more.
So let's think about this for a minute. Looking at Brother Ward's book, it says, let me tell you what it says here. Accordingly, whether to send the indictment into the jury room for use during deliberations appears to be a matter for the trial court's discretion. As a general rule, sending the indictment to the jury room is not error so long as the jury is instructed that the indictment is not to be considered as evidence in the case. So, options are bring them in here, say you've asked for a copy of the indictment, I'm going to give it to you, but then I'd instruct them it's not evidence and not to be considered as evidence. Just like if I'm going to do that, then I don't see the need for them to have the indictment. There's no, unless
they want to see what the indictment.
There's no relevance to it. I mean, I can understand, want to see what the charges are, I guess, or I don't know why they want it, but let's say that they want it, and I tell them they can use it as evidence. What's the relevance of it going back?
It's the state's allegation. So I would ask for an instruction that if you're going to consider it, you can only consider it as an allegation.
Well, I mean, that's what he's saying. It's not used as evidence.
Right, or not. I mean, I don't guess I have a feeling one way or the other. What do you think? Jury instruction.
They did.
Yeah.
You can allow the state to reread the indictment to them and not send it back if that's what they do. Yes.
So only instruction. That's maybe let you reread the indictment, but then I would just reread the instruction I've already given, saying it's not to be considered as evidence.
That's a fine compromise.
I don't really see.
And another alternative, Judge, would be just to pass a note back saying that the indictment is embodied within the instructions the court's already provided, and
I could do that.
it's over. Because when you bring the jury in, every time you do, Judge, they're subject to outside influence, facial expressions of people, the defendant's
Well,
posture, all of those things.
Yeah, I'm not hesitating to bring the jury back in. I just don't want, like I said, I don't want to add to the confusion.
If they want to see it and they're obviously interested in it, I think the compromise might be the best way to go and just read it to them and say it's not evidence. And we'll sit here mute while you do that.
And is the court going to read it or the state?
State.
Yeah. Okay.
He's like, I read enough. I read 16 indictments. I'm done.
In my discretion, let me think about it for a minute.
Yes, sir.
I'll be right back.
Yes, sir.
Okay.
Yes, sir.
Thank you. So, but you can go ahead and get rid of it.
He's wearing his club jacket. He's advertising his golf club. I'm sorry. Anybody who wears pink, I love it. I love it. I think it's great. I'm kind of doing double duty right now, guys. I'm reprogramming this. This is a fancy mouse. Yeah, baby. And I can do a lot of things much quicker. I don't have to hit Control Z, Control C, or Control P. I just hit a button and it's done. Control copy, done. I love it. Well, there's 5 main. With the lessers, there's 16. Yeah. Yep. So let's talk about this. Let me talking about this. What's your thoughts? Where is C1 and C? I'm trying to find my button. Oh, there it is. So, why do I have all this? I don't want all this. So, excuse me while I have a squirrel moment wondering about lesser included charges. Okay, let's have a squirrel moment. I'll go down that trail. What would you like, my love? What would you like to know? Yes, she was abused for a long time. Yes, she was. Unfortunately. Yes. But unfortunately, there's nothing we can do. Here's the thing. My blanket's driving me crazy. I got to refix it. Hold on a minute. Oh, I hate it when it wrinkles up. Okay, I can't focus. All right. When you have someone that has a huge history of abuse, a lot of that can come in and can be consideration. But the problem is, did her attorneys try and do not guilty by reason of mental illness, insanity, whatever? No, she didn't apply. It didn't apply to her. The thing is unfortunately, you can be abused. You can go through the most horrible life experiences. And then when you commit a crime, part of the problem is when you're been out mowing. Hi, Holly, by golly, welcome. No verdict yet, but there has been a question and we're waiting for the judge to come back. The thing for me, when people are raised abused, I was in certain parts of my life. We do come to a point in our life that we have to choose right and wrong.
We know good from bad. Now, if the abuse is so bad that it affects you to the core and your ability to make decisions, then that's something for a doctor and a physical or psych doctor and your lawyers to hammer out before you go into court. I struggle with that because I could have gone down the bad path. I had a lot of bad stuff happen to me, starting at the age of 7 months old. And one day I'll share that, but this isn't the day. But I will tell you, I had to make the choice to be good or bad. That's called free will. And I chose to better myself. Some people can't make that choice. And I really feel bad for them. I feel the system failed them. But you still have to be accountable for what you do. I mean, let's talk about what she did. Oh my gosh, she did such horrible things to that girl. That still deserves consequences. To me, it's like if you drink and get so drunk that you don't know up from down and you commit a crime, you still did it. I'm sorry. No, I'm not sorry. That's my humble opinion and I'm sticking to it. I mean, if the lesser includes are part of the main charge, but the way the judge went over the charges, it made it sound like the charges were their own almost. Okay, so if you have second degree murder, or say first degree murder, not guilty. Second degree manslaughter, not guilty. Involuntary manslaughter, yes. So they kind of go down the list. Yes, 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 they stop. No, no, no. Yes, they stop. I know, it's crazy. I'm just saying, I feel bad for people who go through a lot of abuse. Um, it's a horrible situation for all involved. It's horrible for them, and it breaks my heart. Really does. But, you know, I hate to see it. From what I gather of her, she knew right from wrong. Now, when you get in a situation where she's what I called there against her will, you can go into a situation willingly and then it become unwillingly, and you get so brainwashed, manipulated, and beaten down emotionally, you get to the point to where it's no longer a choice for you. It's life or death. You rather live and do it than die. And I may not explaining this very well. I'm not as eloquent as some other people are. But we're waiting for the judge to come back. He's going to come back in a second and give us his ruling. What they were wanting were the indictments. They wanted to see what he was actually indicted for. It was read to them earlier. They wanted a hard copy. And I don't think they're going to get it. Don't think they're going to get it. Oh, I am hoping that some of the people I've spoke to today might hop on tonight. Maybe. Maybe. So until they come back on, I'm going to turn this back on. We're going to switch. I'll be keeping
Imagine what was going on beyond those walls of that home. You know, we're hearing it. Let's take a listen to more testimony from Rebecca Dishman here, talking about what they did with the body, with the remains after the murder.
So she died, and he says, I'm going to go to work.
Yes.
Is that what you're saying? So what happens? He goes to work, and you're there.
Yes.
I'll be right
From the
back.
time he
Bill.
left
Grab
to
the
the
door.
time he came home, I was on his side of the bed, checking her pulse, and just in a state of shock and fear.
Did she have a pulse?
No,
Did you call 911?
no,
Did you have a phone
no.
at that point? So he comes home from work after he's worked his whole shift,
Yes.
presumably. So what happens when he arrives home that night or early the next morning?
Me and him clean up any blood and anything that's left over, and we brought her downstairs, and he put her in the freezer.
Before she's put in the freezer, could you walk us through again the process before putting her in the freezer the first time?
When we put her in the freezer, Sean was in front of her and I was behind her. And he forced her body to go inside of the freezer, and she made a noise, like snapping noise, and blood went on me, and it freaked me out.
So was she completely naked at that point? Did she have anything around her or anything else done to the body?
She had a shower curtain and garbage bags.
Siobhan Scott, as we listen to what they're doing now after the murder together, taking the body, bringing it downstairs, cleaning it up, stuffing it into a freezer, there's a level of disconnect from
Yes.
being an actual human being, from my perspective at this point. What do you think is going on in their minds in these moments?
Well, I think the two of them are probably very different. You know, he's a sexual sadist, a psychopath. For Rebecca, there's just a disconnect from reality. I, again, wonder about her cognitive limitations, her ability to even see that she had a course of action or resources. So I think they're very different, and I think they had different motivations. It does seem that she was just along for the ride with him, and anything he did, she was going to accept it and go with it.
Dr. Judy Ho, as I heard that description, a snapping noise, that's the body snapping and breaking, and you just continue. Or we're gonna get her in the freezer, and we're gonna clean that up, but we gotta get her inside the freezer, and then you're gonna live in a home with a body in the freezer.
Right. I mean, Vinny, just like you pointed out in the last segment before the break, you know, when people are forced to endure and observe these horrific crimes, they vomit. They have these really intense emotional and behavioral responses. And what she said about that moment when she had heard this body snap was, oh, yeah, some blood got on me and I freaked out. It seems to minimize the gravity of the situation. And every time she's asked a question that was more pointed, like, did you call the police? Did you have a phone? What else did you do? Notice that she just sort of purses her lips a bit and says, no, looks down. I mean, some of that could be a sense of shame of being involved in this in any form or shape, but also, to me, it seems a little dismissive as well. Like she's just so completely detached from the fact that this was a human being that they tortured and committed horrific crimes on for several days. And even her recollection of it just seems so disengaged from what actually happened. And I just wonder about what she's thinking about as she's answering these questions in such a direct manner.
Now, all of this obviously has been disturbing. This next part might be close to the top of disturbing moments and things that you would never expect to hear another human being doing. Let's watch.
There was one or two times that I caught him masturbating to Jennifer.
Could you describe that scene for us?
The first time I was taking a shower and I came in to put my dirty clothes in the hamper and he was masturbating and he held out his hand and I was confused as to what it was until I looked over and he had cut off her nose and intimate areas.
And what did you do when you walked in and saw that?
It freaked me out. I ran downstairs and was almost outside of the door, but he yelled at me to get back inside.
Ran downstairs at that point, you said?
Yes.
And he yelled at you?
Yes.
What happened after that?
After I went upstairs, he
Sorry,
closed
guys.
the door and
I hear that.
made me perform oral sex on him because there was some.
Yeah.
Okay. Siobhan Scott, what we just heard, a description of you mentioned sexual deviancy. This is dark stuff.
Somebody early in life paired sexuality with violence and torture. And yeah, he did not wake up one day with this way of being. This has been him forever.
Bobby Chacon,
The judge has not reached.
have you ever heard of behavior quite like this? The combination of mutilation, murder, and self-gratification, and then the torture all at the same time?
Unfortunately, yes. I mean, we've come across cases like this where breasts have been cut off, the women have been mutilated sexually, and then the perpetrator continues to engage in activity with either the corpse or the dying person. Unfortunately, there are people like that out there like this. This level of depravity is towards that end, but certainly I've seen it before.
Dr. Judy Ho, what do you think's going through his mind as she is reliving these moments? I wonder if he's enjoying the stories.
See that?
I know, when just before you.
Okay, I wanted to talk about that. Oh, I needed to do this. Sensei, come here. I'm sorry. Come on. Come on, get your treat. One thing that concerns me a lot when you have this situation, when you have the perpetrator who commits such horrible crimes and the victims have to testify and relive this crime, to me, that is glorifying what they've done. And how much is he actually enjoying this? Especially when it comes to sexual crimes. Because just because they're sitting in that courtroom doesn't mean that privately they're not enjoying every minute of that testimony. And to me, I hate it. It has to be shared. I mean, she has to testify. I get that. But the problem I'm having is she's testifying and now he gets to hear what he did, the gruesome stuff he did, and then go back to his jail cell and enjoy every minute of it. To me, that's just, in a way, it's re-victimizing the victim. It is. You are re-victimizing your victim. And then it's a third victimization because she's not seeing it or hearing it, but in your mind, you are reliving it. And some of these people who do this kind of beyond disgusting, beyond thinkable crimes enjoy reliving it. That is, hey, Ann. Hello, love. Y'all, please comment, like, and subscribe. It would mean the world to me. So the situation that this creates is it is a lifetime of perpetuation in their minds, even though they get sent to prison for the rest of their lives until they breathe their last breath. They will constantly relive this. And unless they have a come to Jesus meeting and unless they get help, which most often doesn't happen, So what they're doing to him is glorifying it. He's not showing that. He's sitting there because he's on trial for his life. But don't be mistaken, especially when it's definite that somebody did something. It's like Sarah Boone. She filmed it. We know she did it. There's no doubt about it. So every time she sees that video inside, what is she thinking? Is she remorseful? Doesn't appear to be. Is that feeding her ego even more? Look what I did. And I mean, I don't know. It's just a horrible thing. But the victim, because I've been there, gets victimized again by having to sit in the same room across from the perpetrator and say everything they did, knowing that it brought them pleasure.
That I think we're on the same track of mind here. I was wondering if reliving it was a form of arousal for him.
There you go.
Know, like, wow, that sounds pretty great. I wish I was back in that situation right now. I mean, who knows what this person is thinking? I mean, that's what's difficult when we're trying to conduct analysis on a mind that is so far gone from.
And Mom, Polala's mom, the family has heard some of the stuff, but they don't get the full testimony like we're getting here. And excuse me. So for me, it's horrible because they are hearing for the first time the totality and the reality of what their loved one lived through, and it's a freaking nightmare.
It is. I think it's in my discretion whether or not these go back or not. I think that's what the law is in Tennessee. B, I think these were not made exhibits. They're not marked. Only exhibits go back to the jury room, in my opinion. But if I do the suggestion that y'all said and let you read the indictment again, then this is what TPI says. And TPI is not biblical, but it says TPI says. And TPI is not biblical, but and read I says. And TPI is not biblical.
Sorry, I
It
just
says
discovered something new.
the indictment in this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. So that's solely for the benefit of the defendant. It doesn't say it's not evidence. It says it's not evidence against the defendant and does not create an inference of guilt. So if the state tells me that this is what y'all agreed to, I'll do it. Where you read these things and then I'll read that charge.
Okay, y'all catching up. The jury had a question, and their question was, could they get a copy of the indictment? And so he had to go back and double check the laws to see where the law is on that. What he is saying is that the indictment was never added as evidence. But it's up to his discretion whether he gives it to the jury or not. He's saying that if the defense and the prosecution are okay with it, he will read it to the jury so they can hear that clearly and separate from he read it, but very quickly in the beginning of the jury instructions. And I think in the beginning of the trial. But anyway, they're just trying to decide whether or not they're going to read this again to the jury.
But if the state doesn't agree to that, then I need you to convince me why I need to do this. Does that make sense? Because I'm not convinced I need to do it. But if y'all agree, I'll do it. Okay? And I don't feel comfortable changing the instruction saying, for example, the indictment in this case is the formal written accusation charging the defendant with crimes. It is not evidence, period. Because that's not what I charged. I'm changing the charge if I say it's not evidence. You see what I'm saying? Help. So what's the state's position?
Because the indictment itself is not evidence.
That it's not evidence, and that isn't appropriate to go back, and they have the jury instructions, which they're supposed to go on. So since it's a discretionary thing, we being inclined that we don't read it, we don't put it back. They've had it read to them, they had that. And the reading it is the compromise position if the court feels it's appropriate that they rehear it. But we don't necessarily see the relevance in it at this point.
So I think what you're telling me is now, since I told you I have concerns about it, you don't want to do the compromise.
Still compromise.
We'll do it at the court's discretion, but again,
But
we don't lack the concern. I
We're
just
still
don't know that
deliberating.
it's,
I don't want to.
we don't want to do anything that makes it look like there's anything untoward.
So can you help me?
It's safer to do nothing at all than to do something that could sway the jury.
Tell me why. Tell me if it's not an exhibit, right? If it's not evidence, and we agree it's not evidence. Why should they look at it again? And we've already read some once.
Right, so it's been read into the record, so
It
it is
has.
part of the record. And the date, the time and the date frame is something that was an issue. And I know that it's not an exhibit, and that might be what poses the problem with that. But I guess my position is they've asked for it, and it was something that was read to them. And so it is your discretion. And I don't have a legal argument outside of it. I mean, we're in the same position, but.
Can you tell them, if you were to read it to them, could you tell them to refer back to your previous instruction on page such and
I
such?
could, but the problem is with that instruction, it doesn't talk about evidence for both sides. It just doesn't say it's not evidence. It says it's not evidence against him. And there's case law, respectfully, that says just because those dates don't match up, not a basis for dismissal.
I know, I've seen the case.
So basically, I'm going down a path that there's not a legitimate path to go down, if that makes sense.
Well, then my argument would be if there's precedent where a judge has, where this has happened before, and a jury has requested the indictment, and the indictment has been provided.
The case that I read, the judge sent it back, and the defense said it was error by them sending it back.
Okay.
And then that's when they said, the instruction said it's not evidence, no harm, no foul.
Love to see him in the Karen Reed
That's what the
trial.
case says. There's not a case specifically says
Right.
that where they
And
asked
that's what
for.
made it harmless error.
Right.
And that's what leaves it to your discretion.
Right. Exactly.
But in the last case was the exact opposite situation.
Correct.
Which we're finding ourselves an awful lot in this case, in the exact opposite
Correct.
situation. And so I would say that the precedent is strong that it's okay to send it back there, that there won't be error. It's harmless, even if it is error, and that they've asked for it. And it was something that was read to them in the beginning. So I think
Look at all the people on the
the cautious thing to do
prosecution side.
with the instruction as opposed to withholding.
And I assume you wouldn't.
Oh,
if I
wait
give
a
them
minute,
the
who
instruction,
had
you don't want me to leave off the part that says it's not evidence.
The defendant lived on Fairview? Is that what you're telling me? Who? Holy crap.
Just against your client.
I don't, because that's.
If I ever saw Fairview Road and I was looking at a house, I'd say, don't even take
And now the state
on
says,
that road.
just leave it alone, basically. I'm not answering any questions. What happened was I brought the computer in there to set it up and push the button to play it. And while they were doing it, I think the foreperson said, can we have a copy of the indictment? So that's the reason I brought y'all back here. So I sent a message back there saying, if you have a question, put it in writing and send it back up here to me. So let's wait a couple of minutes, see if they send me a question in writing, and then I'll come back and decide one way or the other. And maybe y'all can think about it and see if you can help, not to be disrespectful, but see if you can give me some more meat on the bone.
Something more than is good for my case.
That's right. That would be good.
So, poor guy. Sometimes questions like this come up that haven't come up before. So, oh my gosh. Okay, that gives us a little more time. We're going to go back to the other video. We've had a little bit of a breather. You guys, once again, if you have children or anybody around that cannot handle this kind of content that may have more explicit conversations about intimate moments, probably should leave the room or put your earbuds in.
Yeah. Oh my gosh. I got both down. Hi, Dr. Butter. How are you? Thank you for joining. Thank you. Oh, sorry. You don't have a visual. My bad.
That was our first argument. He
Is it hooked up with relationship? You take a listen relationship.
and decided to move in with him 2 weeks. I had met Sean on Facebook and decided to move in with him 2 weeks after meeting him. He convinced me.
So how did you feel about trying to move in with Sean?
At the beginning, I felt, comfort and safe.
You said that he had convinced you to move in. Could you tell us about that, please?
Like the first text that I recall is he was telling me that he wanted me to move in with him, that he wanted me to live with him and be his girl.
So what were things like when you moved in?
The first couple weeks were okay, and I went to go take a shower, and that was our first argument. He pushed me, and I ended up cutting my leg pretty bad, and that led to my first punishment. My ex had messaged me and was texting explicit messages, and it led to him getting angry with me and shoving me in the shower, which I cut my leg and fell.
Is that the only time something like that happened?
No.
Tell us about the next time you recall.
Later, when I got out of the shower, he told me that, he wasn't happy with me, and there was consequences to that. Like, I had to have sex with him, and he tied my hands to the bed and scratched me down my back and made me bleed.
Now, how would you consider the dynamic of your relationship? Who's in charge?
Sean.
And you had said you did something that made him unhappy.
Yes.
And that there were consequences. He told you there would be consequences. Was that a normal part of your relationship with Sean Finnegan?
I didn't know that it would come to that extent. Like, I knew it would be kinky sex, but I didn't think it would be violent as it was.
Dr. Judy Ho, as I'm hearing this description, something jumped out to me, that consequences, like punishment for her, is to have sex with him. That is,
Right.
I mean, that to me, that speaks volumes about the nature of this relationship.
Exactly. And it sounds like this pattern was established very early on in the relationship. And I think there were people who were talking soon after his arrest that there was some kind of a master-servant relationship that was established between the two of them. And he very, very quickly asserted his dominance, which of course is easy to do when you are older, when you have the power because she's moving into your place. And I think when he knew that she didn't have many other great options at the time. And as she's speaking about this, you can see that there was a sense of powerlessness, but also when you think about how young she was 22 or so when the arrest, or at least the torture of Jennifer and then the eventual killing happened. You know, at that time in your mindset, you are still thinking about things like punishment and consequence, because when you are a child, it's like, okay, you got put on a timeout. It's things like that, except it just gradually got worse and more depraved. And there was always a physical abuse element involved as well as a mental abuse element.
Bobby, what are your thoughts about, you come across someone like this, right? Law enforcement does, and you see his age and you see what he was, what you believe he did. Does the investigation include trying to figure out if there are other victims out there, other people who maybe were homeless, that there weren't necessarily people looking for them? And you know, I can't imagine this would be the first time.
Absolutely, you do. You have one team that works with the prosecutors on this particular case because you need to move this case along in court, and there are deadlines and there are hearings. And then you have another part of your team looking at this guy's background. This is probably not the first time he's done it. So let's look where he's lived. Let's look at missing persons. Let's look who he's worked with, who he's associated with, who he's socialized with. He met her on his Facebook page, so I would look at his Facebook pretty closely and things like that. Sure, you have a whole team that would delve into this background because of his age and his ability to so quickly dominate her and get her into the fold and become like a psychological prisoner. I would seriously doubt whether she's the first one that ever fell under this type of situation with him.
Siobhan, Scott, what are your thoughts about the nature of this relationship?
You know, I see a young woman, again, very young, 22. He was 52. She clearly did not come from an optimal, ideal background, and we don't know the extent of that. But it sure looks like a trauma bond. She said her words were comfort and safety, and that's what she was looking for, and that's what he offered her initially. And so he was also a monster. He hurt her. He did terrible things to her, unspeakable things. He defecated on her. My God, the shame, you know. And yet he bought her new glasses and he fed her, and at times he made her feel loved. And this is a horrendous kind of relationship for a young woman to be stuck in.
I want to play one more part of her testimony and pay close attention to the end here.
Are you all hearing me?
When you say you didn't expect it to be, you know, as harsh.
I apologize. I had a phone call. Are you hearing me now? Okay.
Or as aggressive, what kind of things would he do then as punishment?
Anywhere from putting me in a dog cage and urinating on me and climaxing, defecating on me, chaining me up with a dog chain, using box cutters on me, sodomizing me, using torch ladders on me, just very violent punishments.
And I understand this is probably hard to talk about, but when you say using these things on you, what do you mean he was?
This is the Richard Finnegan trial, and this is the 22, 23, 24, 5-year-old girl he married, and he's in his 50s, took advantage of her. It's a horrible trial. And we are waiting on the verdict. We are in a verdict watch for this. Can't believe they had court on Saturday, but that's where we are. Broken Baker, you ought to come on tonight. Having my Saturday nights
using them for. What was he doing?
For his sexual gratification.
Okay. So you say he used chains on you?
Yes.
How specifically were they used on you?
It was wrapped around my neck with a padlock, and he made me walk on all fours and act like a dog.
Okay. And the same thing, he put you in the dog cage?
Yes.
Okay. You said he used a box cutter?
Yes.
How did he use
used it
that?
on my inner thighs and cut.
What kind of torch?
A torch lighter.
Like a torch lighter?
Mhm.
Could you describe what that looks like? How is that?
I would get off of here. I don't think you want to go to sleep with this in your brain. As much as I love having you here, I don't want to be accused of causing you nightmares. Yeah, it's bad. I think he's up for the D penalty.
That different than like a cigarette lighter?
It's usually used for like lighting grills and other things like that.
And what would he?
I will be reaching out to you. For those of you who don't know, Miss Jules is going through a health crisis, and I'm going to set up a card shower campaign. So I'll be reaching out to you.
What do you do with that?
He made me perform oral sex on him, and he had his leg over my throat and was burning my shoulder at the time.
Did you love him?
Yes.
Do you still love him?
Yes.
Were these punishments he did and the things you described as harsh or aggressive, did those continue for your whole relationship?
Yes, and they continue to get worse.
Dr. Judy Ho, she still loves him.
Bad. Go. Bye-bye.
Yeah.
Lesson
And
night.
Sean had a response to that. He kind of nodded, kind of almost like, yep, still got her. Yeah, this is so sad. And you know what makes me think of is essentially he needed more and more of the depravity, more violence to get off. And eventually it just escalated to a point where they had to kill somebody, right, for him to really get off. It wasn't enough.
Sorry. I'll get it back.
I know it wasn't easy, but we appreciate you putting some perspective and analysis and understanding for all this. Dr. Judy Ho, Bobby Chacon, and Siobhan Scott, we will see you again soon.
Okay. That is where we are. And I would suspect any minute now that, well, it depends where in Tennessee they are. It depends where in Tennessee they are, because depending on where in Tennessee, we could have one more hour to wait. So I am waiting with anticipation. I just learned something. See this little round button that turns? I can come back. I can go forward. Get more precise movements with this. This is awesome. This is so awesome. I love new gadgets that actually do what they're supposed to do. So, you guys, I am so sorry, Broken Baker. This has been a little more gruesome than I normally deal with. I normally don't do these trials very often, but at the same time, I'm hoping people would educate their young women and men. I want to know more than anything. I want to know, what was it that made this guy so horrible? Baker, don't tease me. What do you mean, Mr. or Miss Jar? What do you mean? Yeah. So we're just going to go to straight verdict watch now because we don't need to have that content up there. Where is it? There it is. Save. Scroll. Okay. For those of you who are in the continental U.S. and who are free at 7 p.m. Central, I have invited several people to hop on tonight. I don't know if they will be able to, but we have multiple people that I've invited. So I'm hoping, even if they come in for 10 minutes, just to come on, say hi, be a part of it. You know how it goes. So, I got to blow this out. Yeah, getting too liquidy. And for those of you who are just joining, a friend of mine whose son is doing a science project is doing research on little jumping spiders. Do you know all those little cute ones that everyone's keeping as pets? So they had asked 3 people, one in the east, one in the west, and me in the south, if we would collect a jumping spider, create an environment, and then he will send us questions and we send him answers and pictures. And this is my environment. Probably could see a little better from the angles. It's the tree. Look at that. I missed water on it, so that's how you water the spiders. You don't have a water bowl, they'll drown. And then I made everything except for the fence in the background. And there she is. This is a female right there. But look at the environment. Do you know that these things sell for $100 or more? And they're not expensive to make. I had all the stuff. Now this one doesn't have a spider in it, but it's got, I kind of did it kind of like a boy, a boy might like. It's got the gears, and someone said steampunk, and I went, yeah, I'm going to sell this after I'm done with it. But look, it has a table and chairs. These are buttons that I cut and glued together and made the environments. This one doesn't have the spider in it yet because the spider is too small. This one is almost too small. But we don't have, I don't know where they are. And they don't get really any bigger than your body, than your thumbnail. Where did she go? She disappeared. Oh, there she is. I want to make sure she didn't get out. And so in this one, there is the little itty bitty one that's too little. Let me do this. That's too little. I know some people can't handle spiders. It's okay. I can't handle jumping spiders. I don't like tarantulas. I don't like any of those. These babies are cute. When you look at them up close, they're cute. But these will be released back into the wild. So don't worry. They will not be harmed. They're probably enjoying the air conditioning right about now. So we still have nothing yet from the court. Let's see if I can find something for us to watch. Oh, anybody follow the gymnastics drama? I was a gymnast, so I followed the gymnastics drama. And my thing is too far away. Sorry about that. Anybody follow the gymnastics drama? Closure in the Jordan Childs Olympics medal dispute doesn't seem to be coming anytime soon. The U.S. gymnasts and the U.S. Paralympic Committee are still battling in the courts to get Childs back in the bronze medal that she won on the floor exercise in Paris 24 Olympics. They might have a pretty solid case for the appeal after it was discovered that the chair of the court arbitration for the sport panel ruled Childs' score inquiry was not done in the proper time, subsequently vacating the score that moved her from 5th to 3rd place, stripping her of the medal. Was a lawyer who represented Romanian interest in a legal proceeding in 2011. Oh, we getting some shade. Okay. Let me explain for those of you who don't know. Miss Jordan Childs did her routine at the Olympics. And what happened was they do the same routine they did at the Worlds. And her routine, every routine gets a difficulty score. Well, what happened was, and once again, guys, don't go anywhere because we're still waiting for the verdict. But what happened was is that she did her routine, and when they have an exactly 60 seconds after the end of the routine to turn in to say, hey, well, I'm contesting the score. And they did it in 64 seconds. And so, long story short, the score for Miss Childs was too low for what her floor routine had. And it's all based on the elements that are in the routine. And so the committee reviewed the routine and said, you're correct. The score does not match the routine difficulty level. So they gave her another 5/10 of a point, or 0.5. Yep, 5/10 of a point. And then they applied the scores the judges gave, and it bumped her into third place, which, as a gymnast, and I understand their stuff, is legit. Well, Romania got pissed, and the Romanian national representative got pissed. How are we waiting on a Saturday? I'm confused. He opened up the court. They did their jury instructions, and they're deliberating. They will have tomorrow off, but nope, you didn't miss anything. I'm just talking about the situation with the Olympian Miss Jordan Child situation. So let's read a little further. After the bombshell news was unearthed this week that the CAS is doing its best to save face, releasing a statement vehemently denying any such corruption took place. So what they're saying is one of the people on the CAS committee is an attorney that represented and had interest in legal proceedings for Romania in 2011. None of the parties involved in this case had challenged any other panel member for the procedure, reasonably assumed that the parties were satisfied. No, they're not satisfied. So what's going to happen is this is going up in the courts, blowing up in the courts, because that person should not have been a part of that if they have had any legal dealings with the Romanian team or the Romanian whatever back at the time. The court condemns the outrageous statements published in the certain U.S. media alleging the panel and more particularly its chairman was biased due to other professional engagements for the reason of nationality. As none of the parties involved in the case has challenged any panel member during the procedure, it can reasonably be assumed that all the parties were satisfied to have their case heard by the panel. Any subsequent criticism without foundation or merit. The New York Times reported that all panel members are required to complete a conflict of interest form before reviewing any case. The chair, Hamid G. Gaharvi, allegedly disclosed the legal work he does not he disclosed the legal work he does for Romanian government, and even if it's true, the optics of the chair with the strong Romanian ties stripped an American gymnast of an Olympic medal and awarding it to Romania is not a good look for the CAS. And that's true, especially when the U.S. gymnast has video evidence that child score inquiry was done in the allotted time period. The Romanian Olympic Committee recommended Childs and Romania on Anna Barbos and whatever all be awarded the bronze medal due to the situation. So if they can't get it with one, they want them all because they still get one. Hell no. If they have video evidence that the inquiry was made within the 60 seconds, they're screwed. Michael Simmons will always be the GOAT. Yes. Yes. And I knew Mary Lou Retton personally. I was a gymnast during that era. I met her, spoke with her. It was so cool. But anyway, this whole thing over the medal really pisses me off, and I don't see how that person could be a part. Am I coming off my? Am I still on? My mic stand has not been happy. I move it too much, I think, but it's not been happy. So I'm trying to figure out, is it trying to come off? Yeah, it is. Hold on. Okay. So I don't feel, and nor do I agree, that if you are an attorney or legal dealings for a country, that you should be a part of this. That's my own humble opinion. And it's my channel, so I can say it. They don't like it. Too bad. It is what it is. Do you know that, Sensei, go lay down. Go. Do you know that Mary Lou Retton has an inoperable terminal lung disease that she has to be on oxygen? Yep. I'm surprised she hasn't gone for a lung transplant. She may not be a candidate. She got COVID, I think, and then she got violently ill, and poor baby walks around with oxygen now. Go figure. Place. Talking to my service dog, y'all. All right, so let's see what else. Right now, I'm just going to go ahead and put this up so you can see it, so you know that we are still in. Let me get it. Let me share screen. We're still in this mode. I think I'll do it this way because I don't like having that logo up there that long. So that's cool. I remember. I know. You guys, she is the sweetest bug you ever saw in your life. Oh my gosh, she is so cool and so sweet. I adore her, and I don't think she has a mean bone in her body. Her and Dolly Parton. Anybody into NASCAR racing? What? Simone Biles' resilience Paris Olympics journey continues to inspire two-time Olympic figure skater. There's a lot of Olympians that are starting to be continuing in their older age. It used to be once you hit 22, you were done in the Olympics. George Santos to plead guilty to 2 multiple charges of fraud in case on Monday. Have y'all been following this? Former Representative George Santos of New York, Republican, has agreed to plead guilty after being accused of 5 criminal schemes that sparked his disgraceful fall from the House. According to a person with knowledge of the matter, a dramatic shift from the ex-congressman who has insisted he was innocent. The plea deal enables Santos to avoid trial next month on 23 criminal charges and could have carried significant prison time if convicted. The source states that, let me put this in front of me so it makes it easier for me to read. Oh, I got Dolly Parton stories. I touched her wigs. So does it not immediately respond to the request from comment from the Hill? Okay. Santos to avoid trial on 23 criminal charges that could have carried significant prison time if convicted. The source said that Santos will plead guilty to multiple of those accounts. The U.S. District Judge Joanna Sabert, who oversees the case, will have to accept the deal. I love me, Miss Dolly. Santos did not immediately respond to the request for comment from the Hills. Sabert said that in-person hearing for Monday afternoon after the parties' request for one in a brief afternoon. The party request won in a brief letter Friday that disclosed no rationale. The judge had also granted the request to push back a few deadlines in the case. Federal prosecutors accused the former congressman of 5 criminal schemes, misleading campaign donors, charging their credit cards without authorization, falsely inflating campaign finance reports, fraudulently receiving unemployment benefits, and lying to the financial disclosures. Wow. I didn't know about this. Santos was originally indicted May of 23 on 13 charges, and 10 other counts were added in October. Oh my God. The guilty plea adds a whirlwind 2+ years for Santos with a who flipped a competitive New York seat red in 22. He was lauded, and first openly gay Republican who is not an incumbent to win the House seat, only to be ousted from Congress months later after the Ethics Committee published the damning report of evidence showing that he deceived the donors. Oh, wow, y'all. This is insane. Making sure we're still on play. Santos' plea comes after 2 years of his plea comes after 2 of his former aides similarly admitted guilt last year. Oh my gosh, that'll be something I would be interested in seeing. All right, here's my Dolly stories. Multiple. All right, how many of y'all, this is going to coincide with other stars. How many of y'all remember Miss Dottie West, Loretta Lynn, and Reba McEntire? Give a holler if you remember them. Dottie West is deceased, and poor Miss Loretta Lynn is too. God love her, rest her soul, both of them. They were great women in the country music world. Well, do y'all remember Miss Dollywood opened up back in, I think it was 87, 86? I got to Google it. I don't remember the year. I remember I was in school. Dollywood opened no. The 86. Okay, I was close. 1986. So that would make me 15. I and my family went to Tennessee because Dollywood was opening up, and we went for the grand opening week. And we got there, and Miss Dolly was there. She was in her, old, those old Model T, I don't know, some kind of pickup truck or something like that. Anyway, covered in flowers and butterflies, and had a driver, and they did the parade and grand opening. Well, day 2, I met this cute boy at the funnel house. And I kept going back for funnel cake. I was probably all of 75, 85 pounds. I was a little thing, and I kept going back for funnel cake. I didn't buy, my parents gave me souvenir money. I was like, I'm getting me funnel cake because we don't have this in Texas. And so I was enamored with them. And the young man, he was 17. He goes, well, I'm off tomorrow. Would you like for me to show you around? And I'm all like, sure. And so the next day we were there. We had a week long, I think 4 days, something like that pass. And so we met up, and he started taking us all over, and some of the vaccine things that you normally had to pay to go see. And he looked down at his watch. Back then it was the old fashioned watch, that had the little digital times that were all, we all remember the first little digital watches. We thought they were so cool. And he goes, oh no, I got to feed Miss Dolly sharks. I said, she ain't got no sharks. He goes, yes, she got some sharks up there in her apartment. I said, she doesn't have an apartment. What are you talking about? I don't see an apartment. He goes, you know that Applejack store we went in? Yeah, right upstairs is her apartment. And I was all like, oh my gosh, I didn't believe him. I called his bluff. He goes, well, come on. I said, I'm going to get in trouble. He goes, she's not here. She was out at a recording studio. I don't know where she was, but supposedly she wasn't on property. That's why he needed to go feed her sharks. And I'm like, okay, fine. I'll call your bluff. So I go up there, and you go up these little stairs up the side of the building. And we went in, and there's an apartment. And they're huge shark tank. But the sharks were like this. They were babies. He wasn't lying. And I'm like, whoa, Dolly Parton's apartment, cool. So anyway, he goes, well, you can look around, just don't touch anything. I got to find a better way to mount this. He goes, look around, but don't touch anything. I'm like, girl, come on now. I'm going to touch. Everything that we would have that would be chrome was gilded in gold. I kid you not. The faucets, everything. It was typical 80s. So you know how the 80s, it was a lot of white leather, gold trim kind of stuff. You know what I mean? Nothing too ostentatious, but it was definitely glitzy for me. And I got to go TT. And he goes, well, get in there and use the bathroom. But don't use the towels. Don't wipe your hands on anything. I'll give you some paper towels. I said, okay. So I go in there. I went to the bathroom on Dolly's toilet. Shh. And then I come out, and there's a closet that was open. And all these wigs were lined up, and all these costumes, and all these clothes. And she had her shoes. And I mean to tell me, yeah, like a Dynasty set, but a little more classy. I mean to tell you, y'all. Had a little bit of country butterfly mixed in. Y'all. That girl's waist was like this, you know. But anyway, I'm just standing there, and I go, touch, just kind of ran my hands down the clothes, you know. Oh, I know. I couldn't. That wouldn't be me. And all of a sudden, let's see if you can hear this. We heard click, 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 click. I'm like, oh, shit. Now, back then I didn't cuss, but I thought it. He goes, come here, come by the shark tank. I come running in there. He hands me the paper towels. I wadded them up in my hands. And she goes, what? Baby sharks doing? Are they acclimating well? And I was like, oh my God. I'm like, hi. And she goes, and who's this cute little thing? Is this your girlfriend? He goes, yes, Miss Dolly. This is, and I was like, you know. And she goes, well, welcome to Dollywood, darling. Where's you from? And I go, Texas. He goes, you have a long distance girlfriend from Texas. Good for you. And she was just a doll. So she goes in her bedroom, and he's sitting here feeding the sharks and doing everything. And he goes, okay, Miss Dolly, bye. And she goes, wait. I'm leaving. She goes, well, darling, have you been around the park? And I said, uh-huh. I was here day one. She goes, oh my gosh, really? And I said, uh-huh. And then she was like, okay, come on. I'm going to show you around a little bit. And they had this golf cart, of course, is all decked out and, blinged up, Miss Dolly. And so she and the driver are in the front seat, and he and I are on the back seat. And she's just waving and talking, just as sweet as a little doll.
I've got dinner coming for him at 6. So time to come home. I'll give instructions not to talk to anybody. And then tell them we'll start back Monday, probably at 8:30. Time to come here. Get them here about 8:15, bring them back in here, tell them y'all start deliberating, but you can't deliberate till I tell you to. We good?
Yes, sir.
Thank you.
Yeah. And so, anyway, she goes, well, is there something you've not done yet? And I'm all like, I was going to go to the recording booth. You know, the little booth that they had where you can put the cassette tapes and they had the backtracks and you can sing along with. And she goes, oh, well, it's right there. I'll take you. She gets out. I get out. And she goes, go pick whatever song. It's free. I'll take care of it. I'm all like,
These are four? Yes. Good. All rise, please.
And she said,
Our four girls have a seat right
so what song are you going to sing? Oh, crap.
Thank you. Have a
I
seat.
said, oh.
Hello, folks. Thank y'all for your patience and stuff. So what we're going to do is they're going to take y'all to dinner tonight. So we get to do that. Remember not to speak to anybody. You four cannot talk about the case or have deliberations or anything like that. And I need to do that just in case I've got to put one of y'all in that 12. And I draw the name out. So I don't know who it would be. So we'll do it that way. On Monday, they're going to bring y'all in a little bit later since I don't need you here at 8:15. So they're going to probably bring y'all in at 9. And then we'll just kind of go from there. But I appreciate your patience and hope you have a good time tomorrow. I think they told me they may take everybody to a movie. If they do, they'll put y'all in a separate row and keep them in a separate row.
Really?
Just help me. Y'all stay away from them. Okay? All right. Everybody rise, please. Hope y'all have a nice evening. I'll see y'all on Monday at 9.
All right, these are the 4 people. These are not the other people. Now, what I want to know is, are they sequestered? If they're sequestered, crap.
Yep.
I think they're sequestered. Does anybody know? Hello, Miss Ronnie.
Thanks.
I'm waiting to hear what they're going to do next.
So they released the 4 alternates.
Take your seat, please. So they've ordered your dinner and gone to pick it up. So I need y'all to stop deliberating for today.
Hey, Libby,
Tomorrow, I don't know what all they're going to do. They mentioned a movie. They mentioned going to the park. I don't know what they're going to do, but I trust them because they want to do what's best for y'all. I'll remember my instructions to you. Y'all cannot deliberate. 2 of y'all can't go off and talk about the case. We can only deliberate when all 12 of y'all are in that room, or hopefully we find you a more comfortable room. So that's our only places to talk about the case. And that's really, really, really important. So please help me accomplish that goal. We'll start on Monday. I'm going to get them to bring y'all back about 8:15. So we can start at 8:30 and maybe get a full day in the deliberation and try to get and see if we can get this going or get it done. But I appreciate your effort so far. And y'all done great so far.
Hey, Libby,
just
got another trial, but we'll be watching both. I'll have both
Everybody
of them.
understand that? Anybody got any questions about anything? Well, have a good Saturday night and have a blessed Sunday, and I'll see y'all Monday morning.
You're right. Let's take
All
a minute.
Okay, everybody rise, please.
All rise. Jerry, follow me.
Thank you.
Maybe that's why they went ahead and worked on Saturday. It's because they got giving them tomorrow off, and then they're back on Monday. So we'll have this up Monday along with the other trial.
Thank for y'all. Okay, so I'll see y'all on. I'll bring them back in here probably about 8:30 on Monday morning. Tell them they can start their deliberations then. Okay.
Thank you.
Thank y'all very much.
So we're watching Richard Tellis trial, and I'll have this running in the background. So that's it with that. So let me finish my story real quick about Miss Dolly Parton. So we get to the recording booth, and she tells them it's on me, and so she's standing there. Now, I didn't click. You hear other recordings who have been singing and everything. I didn't know they were going to play it live. If you're in that booth, they are going to play you live. So, she's standing there and she goes, "So what song you going to pick, darling? Did you have one in mind?" And I went, "Daddy's Hands." I just love the song. "Oh, the Judds are my good friends." Well, my gosh, go on in there and sing it. I was terrified I wasn't going to sing one of her songs, but I was adopted and my father loved that song. So I wanted to record it for him for Father's Day or birthday or whatever the next holiday was going to be. So I got up there and I was singing Daddy's Hands. And I was belting Daddy's Hands. Yep, it was May of 86, so Father's Day, yeah. And I mean, I was belting it. Yeah, that's a no shit moment right there. And so I'm sitting here belting it and I'm singing it. And I come out and she's standing there. But the thing is you're delayed. So you got to wait a minute to get your cassette. And I hear myself halfway through the song and I turned around and started crying. And Miss Dolly Parton grabbed me by the shoulder. She goes, "Darling, you did amazing. You're going to have a good voice one of these days, darling. You just keep it on up. I'm proud of you." Can y'all see her doing this? And then she goes, "Well, hon, I got things to do, but I just want to say, girl, you just the sweetest thing." And she signed my cassette. I still have it. She signed my cassette tape. Well, after that experience, we were there for a couple of weeks. We went on to Nashville and all of that. We did the whole thing. But my parents had tickets to the Grand Ole Opry. Now, the year prior, and I think it was 85 or early 80s, 85, early 86, I had a cousin named Mickey Hayes who had that aging disease called progeria. Now, Mickey Hayes was all over the Phil Donahue and Sally Jesse Raphael and all of those talk shows because he looked like a little old man. And he was one of very few in the world at the time that had it. It's a very, very rare condition. But he filmed a movie called Aurora Encounters with Miss Dottie West and Jackie Gleason. Gleason? Oh, she's so supportive of children. I know. And he and Jackie Gleason shared a dressing room on this movie. And I remember Mickey and his family saying that when Mickey came into the dressing room, Gleason was sitting there. Now, he's the guy, the actor had the fake eye, and he'd pop it out and let it roll on the floor. And he took a piece of chalk and drew a line down the dressing room. And he told Mickey, he goes, "Mickey," well, he didn't say Mickey. I can say this because we're far enough in. He goes, "Little shit, this is my side. That your side. You don't come over to my side. You get it? You understand?" And he shake on it. And Mickey has this little itty bitty, hands. He's the size of like a 2-year-old, weighs less than that. Mad eye, moody moment. Yeah. He took him by that little hand and pulled him over into his lap, laughing at him and having a good time. And then he popped his eye out and Mickey had a heart attack. But anyway, they all became best friends. Well, Mickey was turning 21 or 20 or something. I don't know. He was having a big birthday. And so anyway, they gave him a real miniature Porsche. But do you know those cars we buy our kids now with the batteries and they can go? It was about that size, but it was real in the sense it had a battery and everything. It wasn't that fake plastic stuff. It was a cool car. Anyway, so when we went to the Opry, we had all those people I mentioned earlier, Loretta Lynn, Dottie West, Reba McEntire, and Dolly Parton. And I was but see, I just knew Dottie West was there. I was excited to see Dottie West because she acted in my cousin's movie. And every 4th of July, carry Mickey on my shoulders, and I was a little thing. Wow, I got to go backstage and meet all of them again. And Dolly goes, "Don't I know you?" And I went, "Yeah, I'm the Texas girl who's dating." Yeah. She was like, "Oh, hi, honey." Y'all got to hear her sing. Sing Daddy's Hands for them. Oh, yeah. It was those are great memories. Great memory. But oh, a Mad Eye Moody moment. Yep. Yep. And he loves popping. He's deceased now, but he loved popping that eye out and freaking people out. So I guess he had many of them because I'd be afraid of it breaking on the floor. Okay, guys, with that, we are done for now. However, we have I have another live tonight, and we are going to be discussing a lot of cool things. And I have 3 people I've invited on. One is not going to be able to be here. I have 2 others that's going to be having possibilities. Even if it's 10 minutes, I hope they hop on. I really hope they do. It'll be awesome. And I'll be going, I love you, man. I love you, man. I love you, man. But anyway, thanks for the afternoon coverage. You are more than welcome. I normally don't have verdict watches on a Saturday, so that was kind of cool. Normally don't get to see witness statements being reheard and edited either. I thought that was kind of unusual. So we saw a few cool things. And most importantly, Dr. Butler Butter, Pickle Knit, ADHD, Ann, Libby, Ronnie. Love you, Ronnie. Oh, hello, Brit. Who else came on? A lot of new people. Jar, Broken Baker, he's asleep. We had a lot of new people. Oh, yes. I miss Polo. I have a hard time saying this. P. Lola's mom. Optimistic Look came in. Oh, that was awesome. Holly by Golly came in. We had so many of you. If I miss you. Oh, Megan. Megan Einstein came in. If I don't want to miss anybody, but I can sometimes, and I'm so sorry. Oh, Deborah came in. Libby came in. Where is she? There's somebody I'm looking for. She came in at the beginning. Oh, Pop Sugar came in. Thank you guys so very much. Of course, my mods, Sneaky Side, Miss Kevin, and all my mods that were here. Toxic Orchid, thank you so much for hopping in. We had a fabulous day, and I thank all of y'all for choosing to spend your time with me. You are awesome, and I look forward to seeing you tonight when we go live for Spilling the Tea until 7 o'clock Central Time. See you later.